This is still person. क्या कुछ कंप्लेंट हो गया क्या? अच्छा
Were you able to check up about that insurance? This thing was anything done or not?
Insurance aspect.
Insurance aspect. You have to get back whether under that paragraph of the judgment whether the government did, because as informed yesterday, it appeared you had not done it. This is what Mr. Parekh was saying. I just wanted to know, is that the fact? Only as a matter of fact. You've not done it.
No, it's a fact.
Okay.
May I please, my lords. My lords, the learned Attorney General has laid out the facts and the conspectus of the case. And during the course of arguments, certain reports and studies were referred to in his list of dates. My lords, these form the basis of our arguments, and we invite this court to take a slightly different view of those reports and facts on the law. My lords, I have handed over a very short note.
Yes.
The structure of my arguments will attempt, please copy. The structure of my arguments, my lords, will attempt to lay a foundation based on a gross miscarriage of justice and then build on it squarely within the technical aspects of the law as it stands today. But my lords, perhaps first things first, who are we? I am not an NGO. I am not third parties looking to, or busybodies looking to do good at best or at worst profit from the survivors' misery. I am the survivors themselves. I have 5 organizations of survivors who have organized together in various respects. The first organization is, in fact, a trade union of a factory that was set up by the government in order to provide some employment and some succor to the survivors. My lords, if I will have a very brief time, if I could just...
On the papers referred to in the note, are
My
papers
lords,
filed by them, which are
my lords,
not...
I will come to all of it.
I'm grateful for the protection. So, my lords, this factory was set up to provide succor and employment, whatever employment they could do, because there wasn't so much that they could have given the health damage. And the first organization, for example, is a trade union of those survivors.
There are other organizations. One is widows, disabled survivors, others who are claiming welfare benefits as survivors, banding together and supporting each other. All of these, my lords, was laid out in IA 729, and IA 729 was first allowed without any conditions. And then, and at that time, I was 11 years younger, and Justice Lalit was then a senior advocate, was leading us in the criminal curative. And pursuant to those submissions, the court examined the issue and said very well, and this is the order, my lords. That, can you pass it over?
Yes.
My lords, in fact, in a lighter vein, I was briefing Justice Lalit in an entirely different matter in a matter in which our client was, allegedly committed all sorts of terrible crimes. And he said, I was reading about that matter and I would like to help you. And that's how he came in. So, my lords, at the bottom of page 3, no, page 2, is the revised order.
Yeah.
Interlocutory applications number 7 to 9 are allowed, subject to service. That was the part that was not read out on Monday. You notice on the maintainability of the interlocutory applications and merits of the matter. Previous to that, my lords, was the order.
Now, see, your problem is you are constrained by certain part of legal history which has happened, and it's difficult to go beyond it. So one of the issues is that at the relevant time, the courts upheld the norm that the government really stepped into your shoes
Absolutely.
and filed a claim. Once they step into the shoes and that provision is upheld, there cannot be a separate channel of your representation that look as if they have not done the job which they're supposed to do. We are faced with a scenario of a much later scenario of a curative petition. It's not an original petition which we've been telling the learned attorney also. So now, having settled it for A value or B value, whatever it is, nothing prevents them from doing more for you. We are not saying they should not do more.
That I'm very grateful for, my lords, that we will be not left without anything because and demonstrate the hardship that's currently.
They can do more for you. They apparently have not done something which they were supposed to do for you in view of
many things. The governments over there are many levels.
So, but in this matter, we are only our issue is only this: can we, on part of any of your interests,
Yes, Manoj.
pass on anything on them? That's the government stand. That we
Absolutely.
recover from them. Who stops the government from doing something, or from you from saying, "Look, the government should do this more"?
Yes.
That's the difficulty. How do you say a settlement subsists,
Yes, Manoj.
but it's kind of like top up the settlement? So that's the whole issue. Can we top up the settlement which is there?
My lords, in fact, the survivors are relying on now on the documents that have been placed by the learned attorney. And what we are merely
We can't, see, we said in the beginning, we
Yes,
will
sir.
not look into documents, whether of the government or yours or anybody, post what had happened at that stage of time, because it's curative. So the difficulty arises, we can't forget this side that what jurisdiction we are exercising.
absolutely.
And we are
Of course.
constrained by that jurisdiction.
Of course, my lords, the curative jurisdiction is exceedingly limited. And perhaps when we filed originally our application for directions, we asked for the world and we sought too much. So now what we have done today is that we have limited our plea to what has been falling from my lords and to what we see as falling squarely within the technical considerations of the curative jurisdiction, as my lords have exercised in the only 4 judgments that have allowed curative. And we will demonstrate why the gross miscarriage of justice, which is a very, very high standard, is perhaps met here. Lords, if I may go to the structure of our arguments so that I myself don't get derailed, by going on too much about a particular point given. Now, my lords, the second point in the structure, this is on the top page, is that it is now settled law under the law of absolute and strict liability that private profit-making enterprises that use hazardous material in a profit-making activity will have absolute and strict liability for any damage that stems therefrom, and including the example is given if a gas escapes. This principle, and the judgments say this, also exist in significant part because these enterprises have exclusive knowledge of the makeup of that hazardous material, the toxicological impact of any damage that is caused by that hazardous material, the mitigation and the ameliorative possibilities that can then lead to any medical care, categorization, etc. Number 3, there is no other way to say it. We tried in conference to find other more gentle ways to put it. But my lords, a fraud has been played on this honorable court, on the Union of India, and on the victim. The first part, it is because there was a suppression of material facts that go to the root of the settlement. The first study, internal safety study with regard to methyl isocyanate, was commissioned and obtained in
Madam,
1974.
is the fraud period as a ground in curative petition?
My lords, in curative petition, there are 3.
No, we are asking a very fundamental
ma'am.
question. You are intervener. You are.
Yes, ma'am.
Is fraud pleaded as a ground in curative petition?
My lords, fraud is pleaded as a ground in our impleadment application that my lords had allowed. All of this is there. We are only limiting it. We have not extended it. We are only limiting it, my lords.
The problem is this, you see, in some way, you are doing piggyback on the curative petition file. Otherwise, you would not be, intervention would not be. So, when you seek to piggyback, then you can't go beyond the 4 corners of what the curative pleads. You are in a way supplementing that.
The attorneys.
Look, this is a curative petition. We are the affected parties. Being an affected party, therefore, look to our point of view also. But that point of view will have to be constrained, as my brother put it. The 4 corners of a curative.
Yes, ma'am.
So, and the whole problem is that if, now, for example, your point 3.4 is fraud resulting in wrong categorization of injuries.
Yes, ma'am.
This is something to be done by the concerned authorities there. Nothing to do with that, in a sense. Fraud resulting in undercompensation. Again, all this would require, as we said earlier to the attorney also, saying you reopen the whole case, start the trial again. This is the consequence, unfortunately. And what kind of evidence one would lead? You are saying there are some evidence in terms of documents
Yes.
nationally available on their conduct. Okay. But to what extent that conduct affected the people involved is in evidence. It'll be an unmanageable affair, much as you may have a point.
My lords, what we have attempted to do is to propose the cleanest solution that we could imagine in the circumstances. And my lords, if I may just be permitted to go through the structure,
Yes.
and we'll address all the questions when we come to the.
Yeah.
So, my lords, suppression of material facts, this internal safety study and the Carnegie Mellon study that they had, 2 studies that they had commissioned, say specifically that there is major and residual injury caused even when a small amount of methyl isocyanate is inhaled. Now, my lords, I will demonstrate all of this, that this is, of course, the inverse of minor injury. And in a top secret meeting, which we obtained by RTI with the government, the top secret meeting with the government that Union Carbide had sought back in 1985, 2 months after the Bhopal gas disaster, they proposed categories of minor injury, of temporary injury connected to work. And these categories were made their way as is almost in the scheme, because of course the union would rely on the companies. Now, my lords, coming to the next point here, that per the experts And the ICMR reports the injuries resulting from MIC exposures are permanent. Now, my lords, the ICMR, which is the apex government body for medical research, realized the permanent nature of these injuries and indeed the progressive nature of the minor injuries, of even the mild exposure. Because now those cohorts are dying at much greater rate than the normal population. In 2004 and subsequently, in 2009, which is when their reports came out, because they did not have the benefit of the many toxicological studies that the company that had exclusive knowledge had done, and to this date they have not disclosed those studies. What we obtained through the very rigorous United States discovery process where no documents cannot be suppressed. The second we obtained through the Environmental Protection Agency, even though Union Carbide had said to them that please do not, this is confidential, do not disclose this document because it is our property. We have that document. My lords, the next point is that 25,000 rupees is what 93% of the victims got in the first round. And then Justice Muralidhar was leading for these 5 groups that I am now representing before me. In 2004, he came to my lords, and my lords had given another 25,000 rupees in order to disburse the rupee devaluation amount as well as the interest that had accumulated. So the vast majority of people, 93%, and this was read out by Union Carbide also, they have relied on this figure, have got 50,000 rupees over a lifetime of cancer, of liver damage, of chromosomal defect, which comes to about 3 rupees per day. Now, my lords, coming to point B. The settlement consisted of 2 portions, a civil and a criminal. The review judgment is a final determination of what justice will mean for me, for the victims of this gas disaster. That review judgment was concerned with the settlement, which I will be addressing in the first part, and it was also concerned with the criminal. Counsel for Union Carbide then had invited the jurisdiction of this court, citing the Sancheta judgment under Article 142, saying that the criminal cases against Union Carbide can and must be quashed or withdrawn as the union had then proposed. And this court said no. This case must be investigated, that the criminal cases must go forward, and at no point did Union Carbide say that you do not have jurisdiction over us. This argument is without prejudice to jurisdiction. In fact, they were saying you have jurisdiction over the cases. When the decision went against them, my lords, 2 days later, Union Carbide said to the press that this court, our courts in India, had no jurisdiction over them. And 2 months later, they were declared proclaimed offenders. They were declared absconders. Their co-accused were convicted. And today, they are proclaimed absconders. So my lords may consider whether the fugitive disentitlement doctrine enables them to say anything without submitting to the jurisdiction of the magistrate's court and/or depositing some monies before this court should the judgment be against them. Lords, at point C, a US court has found that UCC was evading, this is a federal court, the District Court of Connecticut was evading the attachment order that was subsequently passed by the Magistrates Court in Bhopal to compel their presence by setting up a web of companies, intermediaries called Mega Visa and etc., in order to supply their intellectual property and other goods to this country and for those properties not to be attached. My lords have, of course, understandably been concerned with the fact that what happens now? And what's the point of this entire exercise? Why should 5 judges of our courts exercise themselves then when what is going to happen if the settlement is set aside? Because today, the only thing that we are asking, my lords, is to unravel the fraud and to set aside the settlement. 3 things could follow, depending on what my lords feel about this. The most obvious would be that the interim order would be reinstated. The Madhya Pradesh court had found prima facie liability of the Union Carbide Corporation, the American corporation. They then said, in the review judgment, my lords have said that should the settlement be set aside, that $3 billion worth of unencumbered assets must be maintained here. Unclear whether they'll do that or not. And that the union must return the amount of the settlement to Union Carbide and others. But my lords, there have been analogous incidents of in pari delicto in the past. Why should the taxpayer suffer the burden of this, even of the settlement being unraveled, if it is found that a fraud has been played on the court? In Loop Telecom, and I'll take my lords through this, the current Chief Justice, sitting with 2 others, had found that the doctrine of in pari delicto means that when 2 parties to a contract have exchanged some benefits and one party, at the very least, has committed an illegality, then that is an exception to Section 65, and then that party need not make restitution. They can keep the benefit under the contract. This was in the context of the 2G fee, the license fee that was paid. The third option, my lords, is to look at a Mareva injunction. A Mareva injunction is, the application was made, my lords, everything has been served on them many, many years ago. In fact, we were before Justice Arun Mishra, and we had with the then Attorney General collectively said that could they consider this first, and there was a wedding in the family of, and he said we'll consider it on the next occasion. Now, my lords, the Mareva injunction is founded on a few things, including the frauds played upon this court and the fact that I beg your pardon.
Mareva injunction against what?
Mareva injunction saying that they must, if they are to be heard, then they must deposit a bank guarantee.
The whole concept of Mareva injunction is you withhold some assets
Yes, my lord.
may move out of the
Yes, my lord.
court's jurisdiction.
Yes, my lord.
What is the asset they have here against which a Mareva injunction?
But they can be called on to either deposit a bank guarantee.
They are very clear. See, Mrs. Salvi was very clear in the beginning. We are here to assist the court, but we are not bringing up any more. So what is the asset which can be, according to you, when you talk about a Mareva injunction? To bring that asset here. See, the Mareva injunctions are utilized. Sometimes the shipment is there, some ship is going by. You detain the ship under a Mareva injunction concept.
That's where it originated.
That is
Actually.
where it
And the
originated.
Anton Pillow.
If there is no injunction, there is nothing to be taken out or taken in, then where will Mareva injunction be?
Fair enough, my lords. Fair enough. My lords. In this context, then only what remains in the Mareva injunction context is that Mr. Philip Lochner, who is the former Securities and Exchange Commissioner in the United States and a professor of law now, he has placed an affidavit before my lords in this case, once briefed on this case, and he was shown documents, to say that it is unlikely that any judgment against them will be, it will be difficult to satisfy, and hence they should deposit a Mariban injunction is supportable and they should be called upon. And he also said that there is a distinction.
But
My lord, I am
only-
giving the Mariban
only-
injunction.
only
to
one
all who do
thing.
not wanted to come in my way.
Please remember that you are not arguing the original suit.
Yes,
We
ma'am.
are in a very, very limited jurisdiction of a curative petition filed by Union of India that also is not filed by you.
Yes,
So therefore, there are some constraints on that.
yes, ma'am.
We are not arguing, we are not deciding the original suit.
Similarly, in Pari Delicto, etc.
My lord's anxiety for the victims when the matter was settled back in 91, my lord, was really well taken. And it has been repeated over and over again in the 89 judgments, in the 91 judgments, that we are deciding this to bring succor, to bring justice to the victims. And that was the intention of the union, and that was the intention, my lords. The word midnight has been used in conjunction with settlement to say how fast it was, how quick it was. Then that's the only implication, and no other implication can or must be drawn from that, because these are my words.
I would disagree with you. That's not how this word is used.
My lords, then that may be struck off. That may be struck
Yeah,
off,
what is
and that
nothing
is,
to be stuck off? This is a synopsis of yours.
but my lords, that can be ignored. My lords, this court's anxiety to bring a settlement, my lords have always said that people are suffering right now. A suit could take 20 years. the appeal, as we all know, much of our lives are spent trying to avoid suits and propose other remedies. The appeals could take another 10 years and then another 10 years. So 40 years later, people are suffering. What will they get?
No, there is no question of opening up. That's what I'm trying to tell you.
No, I
This
appreciate
is
that.
not the argument in curative petition. You, in support of a stand of the Attorney General, the only argument is top up. You want to say something on top up? Please tell us what you're trying to tell us on top up. How can top up be made if an agreement subsists and that agreement is not set aside? How can a top up exist? That's the only question we repeatedly put to the learned Attorney General.
Yes.
He gave us constructive view. He wanted us to have a broader look at the whole scenario and see it. But in the meantime, Tilby, I have seen the note. You are traversing a very, very different path. The very different path is like you are opening a suit and saying, please try the suit here in this fashion. That's not what we are here for.
Yes, my lords. My lords, I will invite my lords' attention to also to the 4 judgments in which curative jurisdiction has been exercised and the petition has been allowed. My lords, in 3 of those petitions, it was the issue that was agitated and then curative granted was that there was a gross miscarriage of justice. That those 2 natural justice and bias illustrations in Hurra were merely that. Even in Justice Banerjee's concurring decision, he says that these are illustrative, these are not exhaustive. So, my lords, what we are saying is merely this. What we are saying merely is that if my lords find that there was suppression of documents, and my lords have found Chengal Varya downwards, that suppression of material documents constitutes fraud. And then my lords have said that fraud must be unraveled by the court. So I am merely saying, my lords.
That's not the plea of the learned attorney, which is what my brother put to you. So you can't, you are not on a clean slate, unfortunately. You are only on a prescribed kind of a slate of what the attorney has argued, and you can only supplement it. You can't go beyond that. That's the difficulty. When you are saying, well, fraud, how fraud is to be treated in the case, how fraud will be entangled, how the whole settlement should be set aside, how a fresh settlement should be substituted by
No, I'm not saying that a fresh settlement should be
the whole
substituted.
argument.
No, my lords, for me, just
No
come
fresh
to the last
settlement-
leg.
If no fresh settlement takes place, then try the suit and without any settlement, go to trial, go through the trial process today and come to a conclusion. Now, that's one way of saying that set aside everything which has gone on. This is the purport of your argument, if one reads it. That's not available to you, unfortunately. It's not your curative petition, my brother.
My lords have got exactly what I was saying, except for the last part,
Yeah.
which is that what I am saying is that yes, we have referred to the documents that the attorney has placed, but we are saying that by operation of law,
Yeah.
that my lords may put a different legal interpretation on it. And we are saying that if the settlement is set aside, if the fraud is unraveled and the settlement is set aside, then perhaps there is a simple solution based within the 4 corners of the law that my lords have already decided. 1, that the money need not be returned. And 2, because of the Luke Telecom judgment and the in pari delicto principle. And that 2, that this may be sent. I mean, this court has decided under Article 140, but my lords are not inclined. However, under Article 142, my lords have decided strict and absolute liability in an environmental case without any evidence,
No. Even if you accept the strict liability principle,
with basic evidence.
we are not faced with it. That could have been a path to traverse when the suit was being tried. That don't get into hyperboles of evidence and other things. There's a strict liability principle. How many people are affected? Some evidence would have had to be led.
Yes.
Stage is over. That's what we keep saying. And the curative doesn't talk back of getting back to that stage. Curative only talks about, as I keep emphasizing, and all of us have emphasized, top it up. That's it. In a simple phraseology, they say top it up. Carbide says, I'm not willing to top it up. Should the court direct topping it up? On what principle we've been asking? In a settlement arrived at interested the parties, do we direct a top up of the thing while maintaining the settlement?
My lords, in our respectful submission, that might be difficult. So, which is why
What's the problem?
we have consistently said right from the beginning that based on the same facts, that by operation of law, my laws may apply a different theory.
Theory do we apply? What theory do we apply? See, all honestly seeing this material would be all very well and welcome if I was trying a suit on these principles. Or if the issue was in appeal, and I would say, okay, this is an appeal, these are factors deciphered. Should one permit additional documents to be permitted in a appeal, which have deciphered some aspects which could not have been brought to the notice of the trial court? That is not there.
And intellectually, she's saying that some officers of the government that side. ऐसे हम हो सकता है उनको कुछ
मरीजी की फेज लेके उठा लो See, for example, ICMR reports.
Yes.
You're wanting us to take into consideration ICMR reports. All
The
this
new
requires
ICMR reports.
new ICMR. All this requires evidence.
These are expert evidence. There'll be contrary study. There'll be, yes, you may have some point in them. We're not saying that the reports are not correct, but these have to be then gone through this entire procedure of the
Right.
Evidence Act. These are expert evidence under 45.
Notes.
Then do we take recourse to that? And is that the plea in the curative petition?
My lords, we are not seeking recourse to the Evidence Act. What we are seeking is recourse to my lords' mode of evidence when the strict and absolute liability principle is applied across a number of judgments where reports, reliable reports, for example, the Apex research body, are
Fundamental to law. You can't take reports without putting them in evidence. Now, what probity they can be given in evidence is a separate thing.
Yes, my lords.
You will get the other side the right to cross-examine. How can we say this report is assumed as some kind of a gospel truth? Or take substantively this report into consideration. Take this report also into consideration. Don't ask them to cross-examine anybody. On the basis of this, reopen the settlement. Redefine the settlement in terms of what it is there, because subsequent materials have come to light by which studies have been. These studies will be there. They will want to produce their own studies, saying these studies are not correct. Every study, every expert opinion can be countered by another study, another counter opinion.
That's correct.
Get into it.
The only reason the ICMR report is there, my lords, is to demonstrate that the reports that they suppressed, the material facts that they suppressed when they proposed the structure of the settlement, were discovered by the ICMR much later in 2004 and then in 2009.
What probity to be given to this ICMR? It's a piece of evidence, as my brother said.
Yes, sir.
If it's a piece of evidence, the other side may be able to, in cross-examine, reach the variability of this report, or they may not be able to do it, and this is proof. Everything is trial, which we can't do because that's not the plea.
My lords, we've gone into all the cases decided under the principle of strict and absolute liability. And those are typically writ petitions.
Maybe.
And those are typically 226, decided under 226 or 32, and indeed 142, as my lords were referring to
But
Jaipur
the
Golden.
party took recourse to suit. They filed a suit in the US courts. Somebody thought about it. It's not so easy to say that you will establish your liability. Legal assistance was there. They filed a suit there. Then the issue was whether the suit should be transferred to the Indian courts. The other side wanted the suit to be transferred. Then the judge said, okay, then tomorrow you should not raise a jurisdictional issue before
Exactly.
the Indian courts. That was done. Therefore, you can't say now, okay, the suit was also wrongly filed. Cite this under 226.
No, my lords, we're not
Wait.
saying suit was wrongly filed at all. We are saying we are what our limited prayer before my lords in curative, and we have a very short note, just because there are only 4 judgments in which curatives have been allowed, which we understand weighs with my lords. The kinds of remedies that were given is what we are seeking. That if the settlement is set aside, then any remedy can be taken. Maybe the suit can be pursued, maybe the suit can be withdrawn and a 226 claim can be brought.
Again, you are saying if the settlement is set aside,
Yes, my lord.
that's not the prayer in the curative. That's not the prayer in the curative. Government is quite conscious, and I think possibly rightly so, if my say so, they don't want the settlement to be set aside at all. It is not their case. How can you build a case of setting aside the settlement when the government has not come with the plea to set aside the settlement?
My lords, just for the brief time that I am assisting my lords, if I may invite my lords to consider, perhaps suspend disbelief until we have gone through the judgments, and consider whether
No, we are on fundamental point.
by
If it is-
operation of
It
law,
is not the plea
It can
of the
happen.
person who has applied for curative petition. If it is not his plea that settlement should be set aside, can an intervener say that, no, you set aside the settlement? Can it be done in law? That's what we are asking you on first principles, before going into all these
let me
case law,
finish that
etc.
statement. I'm still a petitioner. I'm petitioners 2 to 6.
No.
I am not an intervener.
In these proceedings, you are an intervener only. You are not a petitioner.
My lords, there is no order. I mean,
Yes.
I am
In
within
case-
what my lords are
In any
permitted.
case,
So they'll follow.
you are not supplemented to the curative petition. The curative petition is only one. You may have been added as a party. Curative petition is only one.
I have supplemented my lords. I've placed
Curative
application,
petition filed by the government of India.
application for directions, etc. But my lords, I'm
Suppose the curative petition was not filed,
yes, my lord.
then what would happen?
My
Where were
lord,
you?
instead of the reason that we filed an impeachment, my lords, was only this: is to all be within the same matter and within the same bunch of paper.
No, you can't do it. It can't be done like this. Either you are in your own remedy or you are in a remedy of somebody else. You chose to be in a remedy of somebody else. When you are in a remedy of somebody else, you are confined by the remedy that person is claimed. If you thought that you independently could file something, so you to file that independently something. That was not fine.
My lords, the remedy that we had sought back then in 2011 was distinct, and it was pointed out. And that, despite that, the IAs were allowed, and then the next day after
What-
the
okay,
new
what
trial
is-
was
what-
created
what-
by them.
What is your IA for? What was it for?
My lords, my IA was for an increased amount based on the current numbers of,
Did you plead for setting aside the settlement?
yes, we did.
So you pleaded for, in the format, what was your application? Was it a review? Was it a curative? Because everything had gone by then. When
It
you
was-
came here, under what was the premise or basis for your moving an application? That's what I'm asking.
It was back in 2011, shortly after the curative was filed.
Yes.
I filed a IA for impleadment
In what?
in the curative
In
as
the
a
curative.
petitioner.
What I'm saying, this is the
My lords, let me
How-
come at it from a
How
different
can you
angle.
be
What
implemented
if-
as a
what if
petitioner
I'm
in that?
merely- even if I'm merely an intervener?
you can't go beyond curative. I'm sorry.
My lords, even if I'm merely an intervener,
Yeah.
if a fraud is placed, if my lords are convinced,
All this fraud, whatever you say, you are saying if a fraud is placed, how is the fraud established? Fraud will require some evidence. Where is the evidence? You say, look, I am producing materials from here and there, government agencies, others. Now, how is that to be proved? Again, evidence.
no,
What
by
does it
reply
mean?
by them, they've replied to it. They've replied to my application for directions. They replied to my.
That's not how a fraud can be proved.
My lord,
Give challenge maintainability.
they have.
That's what's in the notice.
That's fair. They have challenged me.
Please don't mislead the court by saying we've replied
I've
to
read out the order, so I'm certainly not.
That order was
misleading
also
the
that
court, sir.
order also was changed to some extent. It was modified to some extent.
The reason has gone out, this was really the curative main criminal being argued. At that time, the court master takes down. Then when I saw the order, I went to the Chief Justice and said, look, I'm challenging maintainability. His lordship said, yes, we protect them. So he added that.
He kept the first sentence and then he
There's
had.
no question of my replying on merits to him.
But they have replied on merits, my lord. They've replied to the application for directions. It is on record. They replied a long time ago. But my lords, one understands my lord's concern about exercising this rarest of rare, exceedingly unusual jurisdiction. So my lords, the note that we have placed is of the 4 cases that
Yeah.
in which my lords have allowed curative. Lords, if we may come to the last paragraph,
Yes.
the concurring decision of Justice Banerjee.
Yes.
Having regard to the conclusion as above, does it, however, mean and imply a closed door, even if the order of this court depicts that the same stands in violation of natural justice, adversely and seriously affecting the rights of the parties of the same, or the same depicts manifest injustice, rendering the order a mockery of justice? Can it be said that the binding nature of an order of this court cannot thus ever be corrected? Even if it causes insurmountable difficulty and immense public injury, the debate has a very large and wide ramification, and thus will have to be dealt with in a manner with care and caution and with proper circumspection as regards its impact. The principal basis being the concept of justice. Now, my lords, and this is where the principle of ex debito justitiae comes into play. I am not belaboring this point. My lords have this. My lords have read Hurra multiple times, particularly because many curative petitions in the recent past have been brought before us. My lords, in the National Commission for Women versus Bhaskar Lal Sharma, Honorable Supreme Court, while considering the question of a locus standi of the NCW to file the curative, invoked its powers under 142 of the Constitution of India to repel such objections in order to pass appropriate orders to do justice between the parties. Now, my lords, what was happening here? There was a complainant called Monica who was seeking that summons be issued against a particular accused. Now, that particular accused, the court did not issue summons. It went right up and then it went to curative. Monica filed a curative. Notice was not issued in that fact. Then the NCW came. And the NCW said that, look, the ambit of what 498 is, what cruelty is going to be, has been decided, and we think it's incorrect. So will my lords in curative decide that summons be issued to that accused? And my lord said, yes, we will do that. We will also issue notice in Monica's curative and let us issue those summons. No violation of natural justice, none of that. They said that this could result in a gross miscarriage of justice because the definition of cruelty under 498A is under threat. Lords, in Anwar ul Haq versus the state of Delhi, NCT of Delhi, a curative petition was filed against the judgment which upheld a sentencing order that directed that a sentence under section 377, unlawful intercourse against carnal intercourse against the order of nature, and under section 376 2F for rape, for life imprisonment would run one after the other. So my lord said that in curative, there has been a gross miscarriage of justice. So we will correct this. And they sent it to, and they corrected that in the circumstances, the order dated so-and-so, dismissing the review petition is recalled. The review petition shall now be placed in open court before the appropriate bench for disposal. This is all they did. So my lords have consistently crafted remedies where a gross injustice has come before my lords. In Navneet Kaur, my lords, a curative petition was filed and allowed against an order dismissing a petition for commuting a death sentence. A mercy petition was filed and only heard 8 years later. And my lord said that given that it took us 8 years to hear it, and given that there was some significant mental distress in the minds of the petitioner, that we will commute the sentence in curative. My lords, the Indian Council for Enviro Legal Action is a case where my lords had considered what happened in this case was that the review was dismissed and then the curative was dismissed. They said that on consideration of pleadings and relevant judgments of various courts, the following irresistible conclusions emerge. The judgment of the apex court has great sanctity. And unless there are extremely compelling, overriding, and exceptional circumstances, the judgment of the apex court should not be disturbed, particularly in a case where review and curative petitions have already been dismissed. But the exception to this general rule is where the proceedings, the judge concerned failed to disclose the connection with the subject matter or the parties giving scope of an apprehension of bias and the judgment adversely affected the petitioner. Not my case. The other exception to this rule is where the circumstances incorporated in the review or curative petition are such that they inevitably shake public confidence in the administrator of justice and if the judgment or order is allowed to stand. So, my lords, we are merely saying that there are various remedies that when my lords feel that there is something to be looked at
Yes.
in curative, that my lords have consistently crafted remedies. My lords, with regard to the fact that exclusive knowledge in and of itself attracts strict liability, if we may hand over MC Mehta versus the Union of India, the list has been given. Otherwise, we had large pages of compilations, but we didn't want to hand over 1500 pages.
That's something which you look at. Yes, what do you want us to see now?
My lord, this is 1987.
This area,
You should argue that.
would your lordship see the list of petitions? These two six.
My lord,
1 and 3, 1 minute please. 1 and 3, they don't tell your lordships, filed a class action suit in the US. It was then tried on merits, much after all this, and dismissed, holding you have not been able to prove UCC is liable. They carried an appeal to the American Federal Court. That's where they got all these papers. That appeal has been dismissed. Without mentioning all that, they come here, join in as co-petitioners of the union and say set aside the settlement.
my lords, I think that class action suit, if, but my lords, I don't want to get into that. But, my lords,
What he says is you have not disclosed among the 6 petitioners are 2 people who filed separately a class action suit.
I'm going to-
on merits.
I will take instructions on that and I will certainly address
See, the
it.
American
Please
system
ask,
operates very differently. It operates on a Shampati basis.
They must have taken that objection in their reply to your application.
My lords, they've taken many.
They've taken- This objection, of course, you should have taken instructions. Where's the question of taking instructions now?
Yeah.
Strict liability.
This is for what principle? Strict liability, of course, we accept. Who is saying that strict liability is not there?
But my lords, this paragraph is limited to the
Yeah.
proposition
Yeah.
that when only you have the ability to discover and guard against the hazards. And that is why the principle came in at all.
That is how you establish a strict liability. But we are dealing with a settlement, we keep saying. We are dealing with a settlement which has taken place.
Yes.
On what terms and conditions can settlement be set aside? But then that's also not an argument in the curative petition. It is nobody's case the settlement should be set aside. Then how do we do it? Anything else? Rest, we've seen your note and your points, which you have made. You've gone into the proposal by Kaba in how settlement, basically questioning whether the settlement should have taken place in this manner. You've gone into that, well, in the criminal proceeding, they're absconding.
My lords, at page 11,
Yes.
Can you get the reference, please?
1994 one is
No, 10. 1994 1 SCC page 1. my lord.
For what purpose?
My lords, that fraud unravels everything. And
That
that,
proposition you said,
very well, my lords. My lords, at page 11,
that is 0.5 at page 11, please.
page 11 of my note.
Then you got into consequences of settlement being set aside. Again, the whole point is that, therefore I said your endeavor is to see that everything is set at naught and start de novo again with the monies which they have deposited being retained. This actually seems to be the line of your argument.
That's what we're saying, my lords.
Okay, thank you.
My lords, we are grateful for the hearing. My lords, while my lords are considering this, in chambers or otherwise, my lords, the two things that I see. One is that my lords may consider whether by operation of law anything can be done, and my lords' jurisdiction be exercised. And my lords, if my lords are not inclined to find in favor, that my other remedies be preserved, because it remains true that 93% of people have had 3 rupees per day. So, my lords, if a dismissal is what we are faced with, could it be on the limited grounds that curative jurisdiction is not allowed?
If whether we allow it or dismiss it, it will be only based on the curative.
But on that
We are not
limited
really-
jurisdictional.
Yes, yes, of course.
Yes.
Yes, thank you. Yes, Mr. Parikh.
Appreciate the time.
Thank you.
I have prepared a very short note. I must say at the outset that my argument is not setting aside. My argument is will not be what has been argued by London Attorney General, that the top up. The sense, my lord, what I am submitting is that if you look at, in briefly, my lord, then I laid out the note. That the settlement, if you read it, my lord, the order which was passed was arrived at as a matter of fact, the directions which are given by the court.
Yeah.
And those directions are accepted by the party. And the court said, we are very happy that they have accepted our suggestions which have been made. To put it very briefly, it is that the plenary jurisdiction and the jurisdiction which existed under Article 136 and 142, which was then made clear by Justice Venkat Chalaya in the majority judgment, was exercised by this Honorable Court. Now, if you are exercising that jurisdiction, in exercise of that jurisdiction, Lordship will find that in review jurisdiction, my Lord, Justice Venkat Chalaya, because that will amount to virtually changing so many parts in the settlement. For example, my Lord, the criminal liability was there, criminal prosecution. That was said that will be reviewed and set aside. Second part, there was immunity which was provided, that was again reviewed and set aside. Then there were some additional directions which are given. My Lord, what comes out from the 89 order, which was read out to your lordships, the justness part of it. Because in para 14 I was reading, what was said was that suppose we are told now that what was being offered by UCC was more than this particular amount, we will immediately issue notice and set aside the settlement which has been arrived at. So if we read, my lord, all the orders and judgments which have been passed, what comes out is that the entire control was retained by this Honorable Court. Under the constitutional powers, plenary jurisdiction, we call it, 142, we call it. And in a situation where you find that the figures which are given at particular point of time, they have become double, triple, or 10 times. I'll also make clear by giving examples. Suppose that situation comes in, the question is that whether the court will be powerless. In my submission, it will not be, because in that situation, what you are doing is that you are not setting aside, you are not even reviewing. What you are saying is that the parameters on which we said that the settlement is just, that parameters should be applied in all given situations. we find,
If the amount had been determined, Mr. Parikh, by the court in its wisdom, sometimes they do it, okay, we'll give ad hoc amount so much. Okay, you may say so. It's a settlement by both of you.
settlement,
It's not the court in trying to see that the settlement you worked out actually practically was implemented, exercise certain powers. But it did not say that, look, we are determining this amount. This is how it is to be
yeah,
done.
Milord, that's what I endeavor to point out when I read, because I'm going to read, Milord, my note. I'm going to read certain passages from the review judgment. That's all, Milord, not more than so that I
On a
make the
fundamental-
parameters of my arguments very clear. to you.
Parikh, I'm fundamentally not being somehow at the moment able
Yes,
to
ma'am.
appreciate.
I'll
How can
Milord,
you say
share.
if the court has determined this amount? It is nobody's
I
case the
will-
court has determined this amount.
Yes, Milord. If you look at the settlement order, just kindly have a look at Milord
Yes.
page 2. Before that, I must point out, Milord, that I am representing Milord Bhopal Gas Pirit Mahila Udyog Sangathan, and there are two organizations. These organizations were in the forefront. Even before Milord the settlement order was passed, they filed a petition that people are suffering. They should be provided medical facilities, etc. And Milord, on their plea, the medical facilities were given to them. Then we filed, Milord, the review petition. In review petition, we were told that no, you have not been heard initially, but in review petition, hearing will be given because it is like post-decisional hearing, which cannot be given in the circumstances. Treat the hearing in review petition as post-decisional hearing. And in curative, we have said because it is parents patria, so therefore we are assisting because ultimately for the benefit of victims, not the Union of India.
That's fine. We are not doubting.
Yes,
What we are
I'm just pointing out this is our.
what we are saying is
Now I'm coming to Milord.
nobody. Now you are putting another nuance. You are saying no. Well, we are asking top up on the basis that this is the court which determined this amount.
No, that's correct. Milord. We look at the order. We just kindly come to page 2.
Yes.
Page 2. Well, that's my argument because I have to Milord.
So there is no settlement.
Yeah.
There is no settlement according to you.
No. There is not. Kindly just look at what it says. Milord. We have to look at just Milord page 2.
Yes.
Yes, I'm going to read that. The order dated 14/15 were passed by the Supreme Court, directing settlement in exercise of its plenary power under Article 142 of the Constitution. The order dated 14 to 1989 notes, having given our thoughtful consideration for several days, we hold it just, equitable, and reasonable to pass the following order. And the order is passed, which I'll read out to Lakships.
Yes.
The order then records the amount of US dollars 470 millions. This is in the order itself.
Yes.
Thereafter, in para 2, the court records its appreciation for the parties in accepting the terms of settlement suggested by this court.
Yes. There will be many nuances.
Reasons noted was
Yes.
pressing urgency to provide immediate and substantial relief to the victims.
Yes.
So, Milord, if you look at the order now, just kindly have a look at it.
We often, in our perception for a larger good, forget this in many matters, egg on the parties, push the parties a little. We try to bring the parties today. We do something between the adjudicatory and a mediation concept. We try to see that if we can bridge the gap between two of them. And parties accept it or don't accept it. Now,
That-
tomorrow, if we start taking this burden that we should not do this,
Because Milord, they took it upon themselves.
we should we should sit like statues and
We have
let the
to go
parties
back.
fight. Very
Well,
problematic issue.
I am not going beyond the parameters of the order which was passed with the Honorable
Court
Court.
said that
There was an anxiety of the Honorable Court to settle it. Somehow people should get immediate because Milord, that's what they said.
is that wrong that people should get the money.
No, what the anxiety of the court was, immediately the benefit should come. And they said so.
So I'm
And
saying-
rightly so, I'm not disputing that.
Therefore, the anxiety was that otherwise the sufferers will be left high and dry.
Absolutely correct. What I'm trying to say is, Milord, when I'm not pitching my case too high, what I'm trying to say is that the court, it's not a pure and simple commercial kind of a settlement which you talk about, where two parties come and two parties ultimately settle. It's not that. It is that there was court's involvement because of the human misery. and human suffering.
I decline
Milord,
this reasoning that there was a court action. Now you're imposing the court as a third party to a settlement.
No, I'm not imposing. It is Milord because the court has put itself.
The court
has put itself.
has
into
given
the-
its imprimatur to
And
a
that is
settlement.
correct.
Court has egged on the parties to a
But-
settlement.
but the question is,
if we
Milord-
have put the larger issue and said, look, how will these people be benefited who are suffering?
Am I taking my
No.
case, Milord, in a different direction? I am probably not able to make myself clear.
You are very clear, Mr.
No,
Parikh.
what I'm trying to say is, Milord, that throughout, because the anxiety of the court ultimately to see that people get some kind of a relief.
You are saying today that the anxiety of the court that people must get succor urgently amounts to the court having decided the settlement of itself.
No, I'm putting it, Milord. No, that's what I wanted to say. I want to make it clear. What I'm saying is, Milord, that the court exercised, and the question came, Milord, before in review jurisdiction. Now, in majority, Justice Venkatacharya said that you have a power otherwise to transfer a suit. You have not exercised that power.
Correct.
It is said, Milord. And to make it clear that how this particular, because there are two orders at least clarifying it. One is the 89 May order, Lordship has said 1989 May order, where the court said so moto that we are clarifying. The second one is, Milord, again following that, is the order in majority. Now, majority says that how we exercise this jurisdiction. 139A, they say it is the horse 139A because we have powers under Article 136 and 142. We have exercised that power. What I am today trying to say, because I must take it forward. What I am saying is, Milord, that at all times, even Milord, when the review jurisdiction came, they said we are looking at the justness even now. And it is sui generis, Milord, jurisdiction in review which we are exercising.
No,
It is
sir.
not the normal jurisdiction
Supreme
we are
Court
exercising.
wanted to see that it should not be a scenario where the claimants are taken for a ride. To that extent, yes, the court did have a look to it. That look, it's not something where peanuts are given, and by compelling circumstances, that settlement is thrust on. This is even though the government was representing the party. So government is not. I've been telling the attorney, nothing prevented you from lending help from your own pocket and recovering it. But we are conscious of the economic scenario of the 1980s and 90s. So we may have waited with the government at that stage. But the court, yes, in the larger role of a protective umbrella,
Actively involved in it.
Mr. Parekh,
Yes.
Order 23, Rule 3B is very clear. No agreement or compromise will be entered in a representative suit without the leave of the court. So there are always an involvement of the court in a representative suit. To that extent, yes, you are right. There's an involvement of the court. Beyond that, to say it's a court direction which led to court made the calculations and calculated the figure and therefore thrust it upon the parties to agree. That's not correct.
I'll put it not this way. What I'm saying is that we naturally the talks of settlement were going on. There's no difficulty about it. The court came into picture and said, now we are giving this order because naturally.
What are you wanting to say, Mr. Parekh?
That's what, Milord, what I'm trying to say is I must make it clear. What I'm trying to say is, Milord, that in the review order, when the majority looked into it, they said even now what has been said and what we clarified in May 1989, that the justness question has to be looked into at every stage. And they said, because that time even the claims had not come, they said even now when we look at the figures, we do not find that the amount which was given was unjust. So what I'm trying to, Milord, submit before Lordship says that those observations which find place in May 1989, observations which I'm going to read, Milord, from the review judgment, that justness component and to see that it doesn't result in manifest injustice, that always remains. And in exercise of that power, Lordships can look into it's a different thing. That Lordships say ultimately, it is not powerless that we will not look into the settlement. Lordships may say that no, even now we find there is no manifest injustice which is happening to the victims, and therefore will not interfere.
it's not
That's
like
a different
it's not
argument.
Like this is a curative, not a review. Suppose, let us say, okay, theoretically, let us examine.
But Milord, I am saying
Tomorrow, these people come and say, okay, to settle it, we volunteer to give X amount more. The court will not come in the way and say, don't give X amount more. That's all. Beyond that, what can be done?
Milord,
Can we look into the
no, Milord, I'm
settlement
going to
again?
read.
What you are wanting is again effectively to
I'm-
look into
I'm
the
not-
settlement again.
I'm not going to add anything. I am going to read what your lordship said in different orders. Just permit me to read those paragraphs.
Okay.
I think it will be position will be clear. Now kindly read, Milord, the first one. I will not read the entire, I'll just indicate. The 1989 1 SCC 674, the first order. First volume, Milord.
You want to again make us?
No, as I said,
I thought you were reading this note so that this will give some. kind of-
I'll read the note first.
I think the best thing is you read the note.
Read the note and wherever required, Milord, I'll show the paragraphs. I bow down. I have no problem. If my point is clear, Milord, then this note.
Yeah.
Now, the first one I said, Milord, the para 2, which I read out, your lordships, 2 is, the settlement was therefore not an ordinary settlement in a suit between two parties. It was an order of the court which was accepted by the parties. That's my submission, and I'll read, Milord, that order and point out. Milord.
Very difficult to accept this, but you are
Yeah,
entitled.
Milord, I'm Milord, my submission.
You are entitled to say. I'm saying.
Yeah. If your lordship permit at this juncture, I just show Milord to your lordship that para. Kindly permit me, Milord, so that this point, why I have said
No,
so, because
Mr.
I myself initially was in doubt whether I should make that statement. But when I looked at it, page
Mr. Parekh, 470 US million
Yes,
dollars, which was proposed to the parties, and both the parties accepted it and entered into that agreement.
Yes.
That's what the order of 14th February says.
yes.
So once the parties have agreed to it and there is a settlement arrived at, the matter ends.
That's what, Milord, that's what I'm trying to say. The question is this, Milord.
How does it make any difference whether the parties themselves arrived at the figure of the court offered and they accepted it?
Difference
It's
is
one and the
this.
same thing.
What my lord pointed out, that ultimately court looks at even in the ordinary cases that there is no unjust kind of a thing which has happened between the parties because
Sometimes
court
the
is
court
not
plays, sometimes
new
the court
spectator to the entire
doesn't.
thing.
Yeah. So sometimes the court plays a little more active role. And
It
being,
has to should be, Lord, according to me.
being a nature of a claim which was made on behalf of the affected people, the court played a larger role than that, trying to make sure that there
Because
is.
bro, that is what is recorded by Justice Venkat Chaleya. We have to do it. They said we cannot separate ourselves because
Suppose
jurisdiction we
these
exercise.
Mr. Parekh, suppose these two parties, despite that, had not accepted it. Would the court have thrust it down their throat?
No, Milord, the question is this, Milord. If a disaster like this takes place, that is where the jurisdiction comes in. Even under Article 32, so moto, you take it up and say that something is required to be done.
Parekh, you are
But see,
forgetting
larger
the,
jurisdiction
even as
issue.
per the earlier data, the assets of this company in India, which would have been available, were almost 1/4 of the settlement amount, which was ultimately voted to be deposited in court.
But Milord, nobody is saying that what court did was wrong. I am not. That's not my
I'm not
argument.
saying right or wrong.
I am not saying that.
I'm not saying right or wrong. I'm saying if the court's suggestion would not have been accepted, would the court have thrust it down because there were no assets to get the settlement through otherwise?
There
Where were the assets?
There was an undertaking. Even that question has been looked into by
Then
Justice
would have,
Venkat Chaleya.
then would have, no, then would have been a trial.
No, Milord,
The
that
trial
is,
must
this
have
is
taken place.
undertaking
To save that issue of trial.
3 billions which were, Milord, were maintained, and Manager Attorney General argued that point that even if it goes and that remains, that is good enough for us. That is much more than what is being given. So, Milord, that's not because, but then that's not the argument which I'm advancing. What your lordship said, the Lakshman Rekha of jurisdiction. I am on that point. The Lakshman Rekha of jurisdiction is the plenary jurisdiction and 142 jurisdiction, 136, which is the Sound Court exercise, which it should continue to exercise. And what is said, Milord, in 89, we'll look at the justness. If justness is something which is disturbed, ultimately, we will interfere. That's what, Milord, my argument is. Now, kindly come, Milord, to my note, as the lordship said, I'll finish it. On third, it was for this reason that justification, may I, Milord, read?
Yes.
Yeah. Justification was provided suo motu by this court in its order and judgment of 4th May as to how the sum of $470 million was arrived at. The order categorically states that the basis was justness on assumption of truth. And if justness of the settlement is questioned on the basis of supplemental information or material, having a crucial bearing on the fundamental assumptions basic to the settlement, resulting in serious miscarriage of justice, it will be endeavor of this court to undo any such injustice. And that those who trust this court will not have the cause for despair. Now that's important. That those who trust, and they trusted, everybody, they trusted that what this court is doing is correct. The court records, and even the trust continues, today and even in future. The court records in paragraph 14. Now that's important, that it would initiate proceedings to set aside order of 14 to 1989, even suo motu in a certain eventuality. Just read me not that paragraph 14 of that, because that has not been read out to Lordship.
Arik, it was not in vacuum that some observations were made. The
Observation was this.
The observations are also made in the context of an endeavor to lead demonstrations against the court, etc. They've all been penned down in the order also.
So, that's correct. So, therefore, what the court says, that it is not settlement, otherwise you can't interfere. It is settlement between two parties. Court says in paragraph 14, that's where the control of the court, and rightly so, is exercised, because it's not a case between two parties, it's a case on which fate of probably thousands and lakhs of people depended. Now 14 says, we should make it clear. I read it for your Lordship's note. That is a 1989 order. That if any material is placed before this court, which a reasonable inference is possible that the Union Carbide Corporation Limited at any time earlier offered to pay any sum higher than an outright down payment of $470 million US, this court would straight away initiate suo motu action requiring the concerned parties to show cause why the order dated 14 February 1989 should not be set aside and the parties relegated to their respective original partners. I am not saying, what I am trying to point out is this, that the power retained in spite of the order which was passed.
You're not asking relegation to the proceeding.
No, not. I am not on that thing. What was pointed out by Learned Attorney, a charge was given that 70 crores meant for 3,000 deaths. Now, I was just wondering, suppose at that time, this figure which has come now, 5,000 and not 200 something, the figure which is mentioned, the case of death. Suppose it was there, and in 1989, the court was looking into this fairness part of it. Each person will get 1,32,000. 1,32,000. And in case of Milord, the minor injury, a person, according to the allocation which is made in 1989 order, will get only 1,894. And suppose this figure had come in 1989 before this honorable court, whether this honorable court could have said that no, still we accept the amount of settlement which has been mentioned there, or they would have said, look at the situation, because we ourselves have noted that if there is a change in circumstances which changes the justness and the factual basis, then we'll interfere. People should not have any kind of a problem that will not do anything, will just be a spectator and will not do anything. So if we just take this figure to 1989, the position emerges. So 1 lakh alone will then come to a particular individual. Now this is the position. So if this allocation is made, then each person who died, and I'll show me the deaths have been continuing, will get only this much money, and the injured person will get 1,000 rupees. That's why the Union of India said that if the number has increased, then amount has to increase on the same principles which have been given by this Honorable Court in 1989. Nothing more than that. And that is where it is not setting aside, it is exercising your jurisdiction under 142 to say that why you are not paying it to them, because that turns out to be that amount which was given initially to be much less or shocking in that sense. Now, my lord, come to my note, page 3. Milord, 4 is 3. These observations were
For
referred.
diary purposes, the lordships will be continuing next week.
I don't think it'll require, we finish it in
I
the
will need
afternoon.
about an hour at least to show,
Afternoon is there. Well,
and then the rejoinders.
what is under?
Very.
I should finish it.
You have another 10 minutes, Mr. Parikh.
Milord, give me up to 12:30. That's all. Not more than that.
Okay, 12:30. So Salvi will reopen it.
I'm grateful, Milord, because yesterday I was little.
If
Yes,
we say 10
observations
minutes,
are
we will
referred.
take half an hour, 40 minutes. If we say half an hour, you take 1 hour.
2 hours.
This will be done. Our
I-
courts have never been very strict on timing.
Sometimes, Milord, even these observations compel you to really compress your arguments and then you become. So I'm grateful in that sense what you last said.
That's certainly our endeavor.
Now, 3.
Yeah.
These observations were.
Was very fond of an expression Justice Untwalia used. He says, capsule your arguments.
Now, Milord, these, whatever, Milord, wherever Mr. Sarve will take some time, that will be, Milord, deducted from me.
So 12:31.
These observations were referred to in Charnal Sahu, that is para 121, and review judgment in 48 and 174. Para 56 to 65, the review judgment decided the question whether this court had jurisdiction to withdraw and dispose of the suit Deos, Article 139A. The majority justified passing the order of 14-15-89 on the basis of Article 136, 142 of the Constitution. Then 6, in the same review judgment, in exercise of its plenary jurisdiction and powers under 142, the questioning and termination criminal proceedings, the settlement was reviewed and the questioning and termination criminal proceedings brought about by the settlement order was satisfied. Similarly, the part of settlement relating to immunity from future criminal liability was also satisfied. So the jurisdiction continued. That's what I'm trying to say. On the basis of the above noted, it is submitted that the settlement order being passed under 136, read with 142, which is the majority view, and its recognition in subsequent orders judgments. This honorable court has power, which it always retained, to pass necessary orders if it is satisfied. That's your satisfaction ultimately, that in the changed situation, the settlement order ceases to be just, and that continuation of the same order would result in grave miscarriage of justice. And that's a test which you have to apply. You may say even now that will not interfere, but then the power remains with you. This honorable court, in its order dated 4th May, examined whether the settlement amount of 725 crores was just and reasonable by apportioning it under different heads for each category of victims: death, at most severe cases, permanent disability, temporary disability, minor injuries. This amount being provided for immediate relief ought to have been disbursed to victims immediately, as that was the purpose of the settlement. They said immediately it should be disbursed to people. That didn't happen. The amount was meant for the approximate number of victims envisaged under the order of 4th May 1989. Therefore, the interest accrued thereon was also meant for the same number of victims. Justice Khanna pointed out that there is the argument of that it should remain, the interest also should accrue to that number of persons. Cannot be not from that interest to pay to the persons who have been identified subsequently. Subsequently, upon adjudication of claims by the claims tribunal, the number of victims was found to be drastically higher. Therefore, the additional amount on the same parameters be as given in the order of 4th May 1989 ought to have been provided to the additional number of victims. Same basis. This honorable court had retained with itself the power and jurisdiction to grant additional compensation for the victims of the disaster to satisfy the justness in changed circumstances as mentioned above. The present proceedings do not amount to seeking review setting aside of settlement order, but effectuating the continuing process. Now that's not my submission. Effectuating the continuing process of imparting complete justice in exercise of its inherent powers and in exercise of jurisdiction under Article 142, which this honorable court had exercised while ordering the settlement. There is no impediment for this honorable court to hold that if further amount is not granted, it will affect the justness of the settlement and would therefore result in grave miscarriage of justice. You can always see that. In para 174, the review judgment refers to para 38 of May 1989 order, as well as Shalala Sahu, to hold that review proceedings therein were sui generis in nature, and its purpose was to ensure that no miscarriage of justice occurs in the matter, in a matter of such great moment. It further added, it is of utmost importance that great issues of human suffering are not subordinated to legal technicalities. But owing to the fact that the number of affected victims was not available, as it became available later, the judgment said, the material on record, and that's important, material on record, the settlement fund should be sufficient to meet the needs of a just compensation. But suppose the situation was different, and this figure was there, whether the observations which are mentioned here would have been the observations of the court. Because that is going to be now, if your lordships consider what I have said in para 8, that is your exercise effectuating continuing process of doing justice, then now you can look at it and say, now this is the kind of amount which should be given to them. Nominal price. If the material was available to show unjustness of compensation, this court, as it observed, would not have hesitated to do the needful. It is therefore not a case where the court is powerless to look into the settlement order for passing such order which is just and fair. The review judgment, now I would like to review judgment recognizes that's not one part of my argument, which is over. If you lordships want to look at some paras I mentioned, because it will take some time. Because I want to read certain paragraphs in para 10, if you lordships permit, because that is important. The review judgment recognizes the continuing process of adverse toxic impact of gas leak on the victims. Just kindly permit me to read, my lord, some of these paragraphs. Because here, my lord, one question which was put by Justice Khanna, that this in 1989 happened, 5 or 6 years had passed, the figures must have emanated by that time. This precise argument was put by Mr. Nariman, and that was dealt with by the court. Said that this argument, because something, the impact of gas is such, we do not know. It may in future continue because it goes into the cells and membranes, etc., etc. Even now it is happening, because I am going to show to your lordships from the documents of Government of India that people are dying of cancer and renal failure. They are providing to them without compensation of 2 lakhs each. The number has increased tremendously.
We don't know. It's very difficult without evidence to say that whether all this is attributable only to this gas leak, or there are also increase in cases of detection of cancer and renal
No,
failure.
that's what I
Mr.
am going
Parekh,
to
if
point
you
out.
get an
Not,
opportunity, Mr. Parekh, if you get
Sorry.
an opportunity, just go through judgment of the American courts on statin, whether statins, which we normally take as for cholesterol, and you'll find how difficult it is to rely upon data.
one
Very
reason-
difficult. Just go through the judgment. They have done it a fairly scientific formula, but it's very difficult. At times we do get, but then, as somebody said, 3 rupees a day. That's not correct. Obviously, that's not correct.
Because I have been dealing with this, I'm just pointing out what has happened is that there was a direction given by the Honorable Court that you prepare the medical records, because when you go for evidence, you say it is a severe injury or simple
No,
injury.
the government has been considerate. What they have done is,
They have not done it. That's the difficulty.
the government has been considerate because they realized that there could be some cases of cancer, renal failure, etc. So they have increased the compensation amount. There was a big uptake when in 2000, when they make it 10 lakhs, so on and so forth. Then the order of this court, yes, it's not something which was a bounty. You can't say it was a bounty, because whatever amount was paid at a particular time. The payments which were being dispersed were without interest. So they said whatever amount is accrued on either account of interest or on account of depreciation of rupee should be given. Good. But the fact of the matter is, these questions, which amounts have been paid, there has been 20 lakhs in case of death, so on and so forth.
10 lakhs.
10, no, that's been increased.
Yeah.
After 1,504 crores was made, it went
No,
up.
it's 10 lakhs.
No, it became, well, may have increased. It may have increased.
10 lakhs, my lord,
Okay,
with
fine.
ex
I mean,
gratia.
that,
10 lakhs and 5 lakhs, which continues, as I saw, my lord.
maybe. That 1,504 probably was in 2004. This increase was.
So that is ex gratia which is given by them. The question, my
That's
lord, I am
correct.
not
You may be
entering,
correct. You may be correct on that.
I am not entering into that part, my lord, the taxpayers' money, because that is the argument of
So,
Union of
the
India. Why we
question-
should pay, the tortfeasor should pay.
Yeah, if it had
That's a
been
different
something,
argument.
if there was something which was very strikingly, which was found with it, because we excise the power under 142 to do complete justice. If there was something which left us amiss, we would certainly take it. But here, when the figures are given to us, the figures the way they are presented, we don't. That's
No,
where the problem is.
I'm grateful because that's precisely my argument. If you look at it and find that there is nothing which is shocking, nothing unjust, which is really shocking in that nature has happened, please don't interfere. I'm not saying that, but I'm saying don't say that you don't have power. You have power to look into it because that power has been given to you. That's how the entire thing has happened. And if you don't exercise your power, then you are leaving those people. They may have a just claim, they may not have a just claim. That's not lordships may decide. But telling them that will not exercise the power at this juncture and leaving them, Lord, that no, you find out your own way. May in my my submission.
Your argument is basically against the union and not against the UCC.
No, I'm not saying that, Lord.
That's exactly what you're saying.
No, I
That
didn't
the
say that.
union, what it should have done, it has not done.
No, I'm sorry. What I'm saying is, my Lord, the Union of India, for example, medical categorization I mentioned, that medical records were supposed to be prepared and they have not been prepared. Now, if your lordships take that argument as against Union of India, then it is an argument against Union of India.
Correct.
Because the difficulty is this, that the victims are concerned. Persons have been given the medical record, the others have not been given. This is the situation which you are facing. This is precisely, the injustice which is being done to whether UCC is responsible. UCC naturally is
Of course,
responsible initially because the gas leaked, but then subsequently the Union of India should have probably done this thing which it has not done. I cannot shy away from that fact. I have to mention that. Now, kindly look at page 29 onwards, para 29 onwards. Page 50. Page? Okay. The lordships have that judgment in 1991 for SCC, page 88, para 29 of the compilation.
Which page is it of the compilation?
Volume 1 of the respondents compilation, page 88.
Volume 1.
From which,
What is the paragraph number?
paragraph 29.
The total of 5.
6.2 it will be.
If we have the
Yes,
curative
that
petition,
goes
sir,
up.
उसमें page 21 पे.
Now, we saw
If
Milord
you have the
3000.
curative petition, आपके पास है ना? उसी में page 21 पे है, review order.
The total of life has since gone up to around 4,000. Now 3,000 was the figure in 89, it became 4,000. And the health of tens of thousands of citizens of Bhopal city has come to be affected and impaired in various degrees of seriousness. The effect of exposure of victims of methyl isocyanate, which are stored in considerably large quantities in tanks in the chemical plants of UCIL, which escaped on the night of 2nd December, both in terms of acute and chronic episodes, has been much discussed. There has been growing body of medical literature evaluating magnitude and intensity of health hazards, which the exposed population of Bhopal suffered as immediate effects and to which it was potentially put at risk. It is stated MIC's most toxic chemicals in industrial use. Petitions rely upon several studies carried out in toxicological laboratory, etc. Though it was initially assumed the MIC caused merely simple and short-term injuries by scarring the surface tissues owing to its high exothermic reaction in the water, it has now been found by medical research that injury caused by MIC is not mere surface tissue of the eyes and lungs, but is of entire system, including nephrological, lymph, immune, circulatory system. It is even urged that exposure to MIC has mutagenic effect and the injury caused exposure to MIC is progressive. The hazards of exposure to this lethal poison are yet an unknown quanta. 32. The estimates of concentration of MIC at Bhopal, fateful night by the board, indicate concentration of 26.70% parts per million. The work environment. This has led to what can only be described as grim and grisly tragedy. Indeed, the effects of exposure of human system to this toxic chemical have not been fully grasped. Research studies seem to suggest exposure to these chemical fumes renders the human physiology susceptible to long-term pathology, and toxin is suspected to lodge itself in the tissues and cause long-term damage to the vital system, apart from damaging the exposed parts such as eyes, lung, membranes, etc. So also alleged that the latency period for the symptomatic manifestation of the effects of exposure is such that a vast section of the exposed population is put at risk, and terms of effect is presently unpredictable. It is said that even in the cases of victims presently manifesting symptoms, the prospects of aggravation of the condition and manifestation of other effects of exposure are stateable possible. Immediately symptomatic cases showed.
These are all arguments, but Mr. Parekh.
These are Milord submissions which are made. On the basis of this submission, Milord, these are what has been said. Just look at 33, last one.
Yes.
One of the points urged is that likely long-term effects of the exposure have not been taken into account in approving the settlement, and the only way the victims' interest could have been protected against future aggravation of their gas-related health hazards was by incorporation of an appropriate reopener clause. Now, this argument continuing, and 135, which your Lordship will pointed out, ultimately in para 205, etc. Well, kindly look at 135. In between the contention of Milord, Mr. Nariman will come, but then kindly look at 135. Page 1. Yeah. No, 134 also, if your Lordship look at, and then 135 bottom I'll point out. But the petition say that in process of evolving what is fair, reasonable, and adequate settlement, some of the elements essential and relevant to fairness and adequacy, such as provisions for future medical surveillance and the likely future, but yet unforeseen manifestation of toxic injury, having regard to the nature of hazard, have not been kept in mind, and therefore the approval according to the settlement is on a incomplete criteria. But UCC would say that Union of India was aware of the possibility of such future manifestations of the effects of the exposure and must be deemed to have kept all those in mind at the time of settlement. Now, the last sentence will come because kindly read this and then I'll read. The principle, that is fourth line, is rightly pointed out by Nariman, take care of the victims who manifest symptoms. But what about those who are presently wholly asymptomatic and have no material to support a present claim? Who will provide them medical surveillance costs? And if at one day future they develop any of the dreaded symptoms, who will provide them with the compensation? Even if the award is once and for all determination, these aspects must be taken into account. And then it goes in, Lord, what my Lord had pointed out at page 205, I suppose.
Para 205.
Para 205, sorry. Para 205,
So,
which my Lord had.
Are there any cases which are asymptomatic at that time?
Yes.
Later on, somebody.
Yes, I'm going to show to Milord from their company.
So those cases could have been covered by insurance.
They should have been covered by insurance, but then, Milord, what is happening like in renal failure? That is again, Milord, what has been said by Lordships is where, Milord, a claim has not been filed. That's not
Claim not filed at that time.
at that time.
So this contemplates somebody filing claim subsequently
It
who
has
develops
to-
something.
It has to be made clear, Milord, because
That is what is very clear.
if you file a claim now, Milord, because the medical
It's not a claim.
insurance policy have not been taken, then Milord,
Then the government should have done it. Secondly, please always keep in mind that both cancer and renal failure incidents today, forget Bhopal. Otherwise, around also there are a number of examples which are coming. Therefore, which case is linked to this problem, and which case is not a
Causation
scenario?
is a big issue.
Causation is a big issue, as my brother.
Milord, this is
Mainly
actually,
because in Bhopal somebody has cancer or has a renal failure, can we say that that must be attributed or causation must be attributed to
Well, it's not, I'm not going to show anything from I am going to show from the records which have been filed with Union of India. And let me finish three more, and then I'll just show that I think that will be end of my arguments.
You have 6 minutes. Yes. Adding 1 minute of.
Categorization of victims was done in absence of medical records. I'll borrow actually 5 minutes from Mr. Salve, if you'll pardon. Four more. Four minutes.
Money will pay.
Categorization of victims that was done in absence of medical records, because of which.
Mr. Parikh, except additional amount is willing to give you everything. Mr. Salve.
Time is not a problem. In yesterday, when 10 minutes were indicated, he said, no, let them take their own time. No difficulty. So, categorization of victims was done in absence of medical records, because of which the victims and dependents being deprived of fair assessment of their injuries, even death cases, an award of compensation based thereon, and enhancement of compensation if with passage of time the injury is aggravated. I must point out to your lordships that this issue arose, and this aggravation of injury part is in pending in SLP, which your lordship said that we'll take it up after the decision in this matter by the curative. The process of finalizing medical records is still not complete. See the last order, 3/1/2023, passed by the High Court of Madhya Pradesh. Can you just have a look at that order? Yeah. After the note at the end, we'll not just look at the order. No, there was an order in 2012, lordship may recall. Sorry.
Just repeat. Just repeat.
Sorry, no, what I was saying is about the medical record, that the position of medical record is indicated in the High Court order of 3rd of January 2023, which is at the end of note. Just kindly have a look at it. I must point out, my lord, there was an order of 2012 passed by Justice Swatantra Kumar, by which the matters were sent to NGT, etc. It was in the same matter. They said you go to the High Court. So then we went to the High Court, filed a contempt. Just look at, my lord, the position in the para 2. It is pertinent to mention that the last report of monitoring committee in return of respondents disclosed number of deficiencies in compliance made as regards directions contained 59(9) of the aforesaid order of tax code, including that nearly about 76,000 health books medical records have been digitalized, as against more than 4 lakhs gas victims to whom smart cards have been prepared issued. Made clear if satisfactory reply is not filed, then court may proceed call upon. So this is the situation in 2023. Then even now the people are searching for medical records. Now, yeah.
I just wanted to know, as a matter of fact, what happened to where the factory was located, the land, and what is
Yes,
happening?
I must come there. Milord, in one of the cases, Milord, which was concerning dumping of hazardous waste in the country, this was also looked into by the committee which was appointed by the Honorable Court. They went there and saw the situation. The water was also, drinking water was contaminated. They suggested drinking water should be supplied. And that question, Milord, drinking water is pending. But besides that, Milord, ultimately, the toxic waste which is lying there, that has to be, Milord, disposed of. So there was again, Milord, it was looked into by the Honorable Court, and a sample of waste was sent to, I think, Taloja, Pitampur in Madhya Pradesh. And then the costs were incurred by the Union of India and Madhya Pradesh. I think they shared the cost. And beyond that, not that what kind of emissions will be there, because they should not be too toxic, which will be health hazard. It is not there, and I'm told that the waste has been put in some kind of a how much? 1.1 million contaminated soil is there, which has to be ultimately incinerated, because we can't put it in landfill. Landfill will not be water.
In 40 years, what did the government do?
Site possession was taken in 84 by the CB Act.
So something.
It's not very.
For everything, they need a court's order to do it.
It's not very.
And then they say the court passes orders.
The court passed some order, it was not done, then court again passed the order, then it was transferred to High Court. High Court will look into it. We do not know what is happening in the High Court. It's now in the High Court. Pending in the High Court. Like this matter is pending in the High Court, medical records. Lordships directed you must do it within a given time. Medical records not prepared. That is also. And what will happen, because you will inhale this kind of a dust, which is toxic in nature, and the water is contaminated.
Stored in some manner, right?
Multiplying problems.
Some storage manner must have been done, or
no. Subject to not correction, I should not immediately say. But as much as I know, because I appeared in some of those matters, nothing has been done. Some waste must have been put, my lord, in the bags, etc., but then nothing more. Entire, and that is there. So therefore, from there, by leachate, my lord, it is going into the underground water, contaminating, and then
I don't know,
this is.
but
We'll put it on record.
very basic common sense would require that the issue of how the area has to be tackled with should have met with priority from the government authorities.
That's correct, no. They can't depend on, because they can recover from UCC, that's a different thing. That's what we said, that you must do it, not in those proceedings in hazardous waste. You must do it and recover it from UCC, whatever you want to do.
But that's the second stage.
Yeah.
First stage is what have they done? You're talking about 40 years or
Nothing,
decades.
they've not done. No, we are para 12. The Office of Welfare Commissioner has been submitting fortnightly reports on number of victims whose claims have been processed and sanctioned. Last of such report is 15/12/2022, shows the increased number of sanctioned cases of deaths, permanent disability, temporary partial disability, as well as number of cancer and renal failure which have been sanctioned. Just look at the last page 1633 only. It's a compilation to volume 4 of Union of India.
What does it contain?
It contains, my lord, the fortnightly reports on number of victims by the welfare commissioner. So I want to show to the lordships, my lord, these are identified cases because lordship said that it depends on renal failure cases are taking place and cancer is taking place, but these are all identified that because of inhalation and the money has been, and that's government document, not, they have put it. Yeah, you have opened it. Just pass it on. This is a compilation to volume 4 of Union of India, page 1633. Only one page, I'm sure.
Status.
We updated the status. I have to show to Lord. So you can't object to the work being done by Union of India. They are providing ex gratia compensation to people. They must show that the number is increasing. That's all. You can't
We
object.
take it that there is an increase in number.
No, my lord, this can you look at this? Is a tremendous, not simple one. The number is increased. I show to the lordship. This is in case of how much is renal cancer cases are how many? Cancer cases are 10,547. Look here, this side. I got it. It's at 10,000, and the renal failure are 1,726. The number of death cases have increased from 5 to something to 5479, and also the cases of increase of permanent partial disablement. All that figure will be clear. Not it.
Not yet.
I can pass on my. I don't want. Got it. Page number is
It's last page of the volume.
1633, last page. Now, the previous thing, these reports have been given from 2011 onwards. Because Lordship may recall, 2010, they came out with the ex gratia payment scheme of 10,000. So then they are monitoring it and putting the report. I'm so sorry, I got that.
Charge. The other thing is that the increase is from 5,200 odd to 5,479.
Correct, whatever it is. Whatever it is, and similarly, there is
No,
a
but
increase, I think.
Tell us one thing.
Yeah, my lord,
One
Lordship,
minute,
look at the last one.
Just 1 minute.
Yeah, sorry.
This is the people who may have passed away. What for the ages is not indicated.
I have no idea, my lord.
You are
What
not
is-
aware.
and what is the causation? Causation is
Position, my lord, because this has been submitted ultimately by the welfare commissioner, and the causation, these are cases which are sanctioned. Kindly look at the last column here.
Government may be helping, putting a helping hand to it. One thing.
They can't give helping hand, this is all cases of Bhopal case tragedy. Who have
I am saying, suppose somebody who
and they can
has
clarify probably.
some effect of Bhopal tragedy.
I have no idea, not some or more. In fact, I am just putting,
No, I'm just saying the problem is at this stage to find the cause and effect, saying that this particular person, this disease is attributable to that. That's what we are
I'll
trying.
not, I'll put 10,000, 5,000 which they mention is the amount which has to be given in case of death and permanent disablement for Bhopal victims. It is will not the continuation of that only. They then from 2011, I have shown the last page to Lordship. The starts from 2011, the monitoring reports are from 2011, how much money has been given. The approved cases, progressive agriculture cases, there are approved cases, I'm reading only that. The approved cases of cancer are 10,547.
Correct, but whether amount compensation is paid to them or
2 lakhs, not they have determined in case of renal failure and cancer.
2 lakhs.
Yeah, 2 lakhs. XPA share they have paid. Now, that question, Lordship may decide that who should pay,
No,
because
I thought,
the judge,
it's fine, just one correction. I think as per the rate fixed by the government for renal failure, it's partial renal failure, disability is 5 lakhs, not 2 lakhs. Subject to correction.
2 lakhs.
No, if you look at the figure given at page 1633,
Yes. Which column, you know?
the rate by GOM is 5 lakhs.
Yeah, 5 lakh is not permanent partial disability.
Yes.
That's all,
In case of renal failure, it's not treated as permanent.
No, it's not treated, they give 2 lakhs, not as lump sum.
Okay.
Both cases in cancer and renal failure, 2 lakhs are given.
Okay.
And they are paid. I'm not saying that this payment is being done.
They don't
It is done
treat these cases as falling in utmost severity.
at most severity.
They don't treat those cases as falling in this category.
No. The separately monitored, no? These are, cancer and renal failure cases are separately monitored. But then why I was reading, where 29 onwards is linked with this. These cases will keep on increasing. Therefore, at that juncture, when you said this is the amount and this is the number, may not be. So at some juncture, may not, even after 1 year, suppose the situation becomes drastic,
That is
somebody
why,
may come
that
to you
is
and
why-
say whether Union pays or they pay is a different.
That is why the review judgment said that there may be possibility of other cases arising.
Correct.
Therefore, take out the insurance policy to cover that scenario.
But that's again, the question is like renal and cancer, then nobody knew that these things will happen because that's why I read out 29 onwards.
Correct.
Only for that purpose.
You are saying that these cases should have been treated as falling in second category.
Yes.
Has anybody gone to the government with that case that you pay more?
No, you gone? No, have you gone making this claim of God that should be treated as a purpose? They have gone this way. There is an application.
This is for the government, therefore I am saying,
Since his time is over, I will point out, there is a parallel proceeding pending in this court by these people claiming more, where the government, and I'm going to read those affidavits, has filed an affidavit saying everybody who's genuine has been paid, all these claims are wrong.
No,
I'll show that.
my friend is talking about the SLP. That SLP has to be taken. I have not argued the SLP because there's an order. It will be taken up
After this.
So if there is any argument, I don't think, because that is aggravation. What has been said, Milord, I must point out, the SLP is this. This simple has become, Milord, with passage of time, grievous. Grievous has resulted into death. Now the question is, when you go before claim, they say, no, we have given you claim for simple injury. Now we can't give you for aggravated. So therefore, now the situation.
So that claim is subject matter of that SLP.
SLP.
This
So,
claim, is that correct?
correct.
When the
Name of
government
this category.
This government is opposing, that's correct, they are opposing, I can't deny they are opposing. But the question is, High Court said, no, we can't do anything because that's the scheme. And now we are in difficulty because naturally if somebody has died, then he has to be paid according to the death criteria. Only one prayer. That prayer is, Lord, kindly ensure the medical records to all these people, they are made available as direct.
You see, you have flagged two issues. In fact, one is, I was just seeing, para 13, correct?
Yes.
Medical servants are utmost
Correct.
important, medical for systems planning, but that data has not been digitized. Number two is,
13. That I have said 20,000 people are in. Now you can't say that there are minor injuries, that they are visiting hospital for such a long time. But whatever it is, not in adjudication is something minor, I can't say anything. In appeal, you can challenge it, but truth is that they are suffering and it is categorized as minor. I'm not making out any point that you lordship adjudicate, but this is a human problem. It's a truth that people are suffering.
okay, thank you.
I'm very grateful to you.
Thank you.
But my time is over. I'm very grateful to lordship.
Wait, please. Two or three things I want to assist you with. The first is a commitment I made to someone. That commitment is to defend allegations of midnight setting. These allegations are haunted. The court has haunted certain very eminent people who were involved in the process of negotiating the settlement. It is very easy to allege this kind of nonsense. Very difficult for those who are called upon to make difficult decisions. Take responsibility. The Attorney General of the day said, my shoulders are broad enough, I take responsibility. I think this is the best for the people concerned. 5 judges who sat there said, our shoulders are broad enough, we take responsibility. There is a whole industry of claim and claimants which has grown around this misery and this tragedy in India. 3 or 4 rounds of litigation have taken place in the United States after Judge Keenan transferred the union suit to India. In different formations, Sahu 2, Banu have brought class action suits in the US, where US people have given evidence. And that evidence is now sought to be introduced before this court, including in some of the papers filed by the government. Extraordinary claims made that the death rates in Bhopal are higher, and therefore 25,000 people have died, 30,000 people have died, etc. And all condemning this as a midnight settlement. But I want to start by telling your lordships that this settlement did not take place in 1989. This settlement started in 1987. The district judge took the responsibility of saying party should explore a settlement. We put all that on affidavit. Yeah. He passed a judicial order saying, please try and arrive at a settlement. The government of India rightly complained, saying Union Carbide is relying upon every possible legal defense, which they would, saying give better particulars, give this, give that, matter is not progressing. The district judge said, please try and explore a settlement. The Attorney General, who was appearing for the plaintiff in the Bhopal district, and Mr. Nariman appearing for the Union Carbide, 2 of the stalwarts who have assisted this court over the decades, started discussing settlement on behalf of their respective clients. The figure started with 350 and 500. The courts always felt that the gap was not that large. A little squeezing from both sides, things could move ahead. By the time it reached this court, it got narrowed further. Mr. Nariman's statement is recorded saying 420 and no more, or 430 and no more. The Attorney General said no less than 500. This court said if you give 470 plus interest, it will be 500. You are happy? You budge from 430 to 470? Surely your client can consider that one. They said fine. So the settlement was signed. This was challenged in 1991, and the prayer in the review was set aside this settlement, put the case back for trial. 1991 was 7 years away, but still, as compared to today, proximate to 1984 or 87, 88, 89 by the time the legal proceedings. Your Lordship said the 5 judges who passed the order on settlement, and we all remember, you were much younger, but we all remember the huge rumpus over the settlement, including one conspiracy theory saying Mr. Rajiv Gandhi met Mr. Warren Anderson in some hotel in Paris where this was done. All these kind of nonsensical allegations. At a time when Mr. Warren Anderson had long retired from UCC. Your Lordships felt the first bench which sort of accepted felt they must state their reasons. It's the strength of this court that your Lordships are never embarrassed to say, in a case like this, we must tell you why we accepted the settlement. While doing so, your Lordship said, if it is found, we went on the footing that Carbide has said 350, 370, 400, and no more. If it is found that they had ever offered more than this, we will annul this settlement. Set you back to face the trial. So it's not that it was a reopener clause saying if it is found you offered more, it will be done. Secondly, these volumes and volumes and volumes which have piled up and occupied space in your Lordship's registry. Nothing has been ever suggested that Carbide offered more in any negotiation or any discussion. And what was ultimately accepted. So that issue of the 1989 order is over. Now, what is the case in the curative? And I was going to, perhaps out of over enthusiasm, interrupting twice, give figures. What I was trying to point out is it is not the case of the government in the curative that they have had to pay a lot more than what was received in the settlement. Why should the taxpayer be burdened? That is not the case of the government. The case of the government is for the hugely larger number of cases, the 520, 530,000 claims which have come, we have had to pay 1,548 crores. But then we still had 1,500 left in the kitty because of various reasons. So the court directed us to pay the balance back, also prorated. So it's not the case that the government is out of pocket for anything. What then is the case? The case is, and that 600 crores figure is very important. We paid 1,500 crores, around one. Forget the surplus which was given prorated. We paid 1,500 odd crores. The settlement, we wanted 500 million or 470 million. Roughly the dollar was about 18, 19 that time. It's about 900 crores. So the 89 money we got is about 900 odd crores. We paid 1,500 crores. 725 crores with interest. The 600 crores, therefore you add that on. That 600 crores what we have paid over the 89 figure, I should be asked to pay. And how they are now saying, now take the today net present value of that 600 crores in 1989, taking into account various factors. And that becomes a few thousand crores. That is claim number one. So it is not, my lord, that After paying all that, there is still 675 to pay. Let's be very clear on what this security is about. If your lordship sees 2 pages, this comes out very clearly. Table B. Because what your lordship will have to decide as a matter of law is, does this kind of a claim fit within your lordship's security jurisdiction? Page 329 of volume 2 of the curative petition sets out the figures. As the papers are being handed over, I just want to mention, I didn't want to bring it up earlier, but since petitioners 2 to 6 have claimed to be petitioners 2 to 6 and are argued, there has been an adjudication of whether UCC is liable or not liable. The American lawyers led all this evidence which they want to place before. The district court said, you have not established UCC's control over the Indian company. The Indian company was a listed company. It made departures from the technical designs given by UCC. It was not being run by UCC. What happened was an industrial accident in the operation, not in the design. Therefore, UCC is not liable. I'm not saying that's right or wrong. That's the finding of a court on adjudication. This was the concern of the government of India in the suit. Because then you would be left with UCIL, who had 100 crores, 200 crores worth of us. They carried it in appeal, and the appeal got dismissed. Now, this is where the only adjudication has taken place. But it's not relevant for us. But since these 2 people have come, they should have candidly told the court, well, we've tried holding UCC responsible, we failed, so we are back here. Please, Bharat, turn to page 329, P7. And since Bharat, it's only 5, the lordship asked, what about the toxic waste? Since I know, Bharat, I'm appearing in the other case, my friend and I have been appearing in that case. I tell your lordship, Needy gave reports because 84, when the accident happened, the CBI came, they yellow taped the property and kicked out. I think in 89, the government of Madhya Pradesh cancelled the lease. 92, they cancelled the lease of UCIL. They took a factual possession was always the police or this. Then the legal possession also, they said, you're out, we are taking possession. Up to 1997. Now, what is toxic waste? Toxic waste is substandard pesticide. Well, today, nobody uses that kind of pesticide, but at that time, government of India wanted this pesticide to be used for our agricultural crops. Pesticide which was not strong enough was kept in pits for ultimate decay and destruction. Up to 1997, NEERI says there is no contamination. First time NEERI found contamination in the water was in 97 because nothing was done. This waste was lying on the ground. Now, what happens in these pits is not every few years you have to change their base, you have to change their lining, you have to do something. Nothing was. So the lining decayed. Because the lining decayed, leaching took place. Leaching took place 7-8 years down the road. The water contamination and other troubles started. So this is what has happened. And that the concerned people have filed petition under the government. Justice Ravindran, as the lordship then was sitting in the Madhya Pradesh High Court. He said, he told the government, and the government's defense there was, ask Union Carbide to pay, ask the Dow Chemical Corporation. Dow Chemical Corporation acquired Union Carbide in 2000. They had no connection in 1984, 2001. Ask them to pay. So they were getting bogged down on is Dow Chemical liable? Are they not liable? Justice Ravindran said, you first get this place cleaned up. Then you worry about who's going to pay for it. Because ultimately, if it is going to affect the health and lives of people in that area, you first get the junk cleaned. That's where things are matters still. So it is not that nothing, that's a matter which is pending in the High Court, and the High Court
That is receiving separate attention there.
Yes.
Just to add, my lords, there's an SLP from that High Court which is pending before this court.
which is disposed of.
No, my application has not been disposed.
I see, SLP is
There are
gone,
two matters.
application is pending, right.
My lords, I have the order here. In the research foundation matter, there were various IAs, etc.
My lord, I can't take anything
If
from
the,
her time because her time is over.
if the SLP,
It's here, ma'am.
no, if the SLP is over, the presumption is no application survives.
My lords,
I'll
there are.
clarify, my lord. There were two matters. One was the research foundation dealing with hazardous waste. So in that, my lord, they also dealt with partially with the Bhopal case. They said it should be cleaned. So in that, there is application which has been filed, must be pending. That SLP has been disposed of, which my learned friend. So that application is happened.
Got it.
So, my lord,
Anyway, my lord, let me come
request
back.
is pending here.
It is not before us.
Anyway, my lord,
My lords.
I have no time to take from them, so let me not waste time on this. Let me get on with what I have to show the
Please.
court. May I start it too, because I have to
Yeah.
read some pages.
See, the whole case which is made out is this: you pay the particular figure. Now, what accrues and increases on that figure cannot be taken into consideration while quantifying the amount, because that figure, if it was depreciation of rupee or interest,
Yes,
as it is done in so many cases in the
absolutely. My point is very simply this. If the,
answer
if the rupee had climbed against the dollar, I could have asked for a refund.
that figure remains static. For you, that figure remains static.
That's the long and short of our history.
Lordship, I request board of court number 7 can be discharged. Waiting for that.
Yes, it will be discharged.
But look, there are alternative boards.
Yeah.
In
The
fact, I was also
alternative
going
boards
to
are
request.
here also, but we are
But if I may say so in a lighter vein, if your lordship want me to finish quickly, then please don't take the alternative board. Because I don't know if you can- Otherwise, like Mr. Ramaswamy used to say, I will have to go on till 4 o'clock.
no alternative boards.
Lordship.
Your board.
We have also board.
So no.
our board is, of course,
Alternative board we are taking.
Lordship. may say so in a lighter vein. Seeing the direction of the wind, I'll be very brief. Let's try to get talking to myself.
But direction of the wind can change also.
That's what I'm saying. Lest I change the direction of the wind. If your lordship is pleased to turn to volume 2, P7. I have one of the very short points to you.
Volume 2?
CP volume 2, page 329. I am only going to assist your lordship on 2 points which I need to assist. Was there a settlement? There's suggestion is that this was something more than a settlement or less than an adjudication. If so, on what basis is the settlement being challenged?
Salvi, it was a settlement. I don't think any of us has a doubt it was a settlement. Yes,
That's what I said.
court
That will
prods.
be 2 minutes.
At times, court prods, there's no doubt about it. Day in, day out in trying to arrive at settlements.
The only
We may have played the local scenario, the court may have played a little more active role in trying to do so. In family matters, every day we do it. Sometimes the bench comes, they say, leave it to this. Okay, we say X amount is a settlement.
there was a
You want
reason
to
why
agree
the-
to it, you don't want to agree to it. And then they say, okay, we leave it to the court too. You
there
know.
was a reason why your lordships did that, because the district judge had passed a judicial order asking the parties to settle or explore a settlement. So the process had been started by a judicial order. And that carried there were 2 parallel themes which were running. While the settlement was going on, the district judge said, I can't wait and see people queue up like this. Something needs to be done. So he passed an interim saying peso, which both sides challenged in the High Court. High Court upheld the principle but scaled it.
Killed it down and then that came up to
That came up in appeal. So there were 2 parallel tracks running. Try and settle, and in the meanwhile pay. Those 2 were sort of coalesced here, where your lordship said settle, if you can. The appeal was argued for weeks and weeks in Court 1 before Justice Pathak, while there were also conversations happening about whether this can be settled, because this had to be not settled obviously at very high levels, at the top of the management of the private company and at the top of the government. It had very far-reaching implications. And that is what was done. So there was a settlement. Now, what has happened pursuant to that settlement? Your lordship sees this one document so that the nature of the curative becomes clear. Page 329, P7. In the course of submission, various questions came up. Actually, what exactly is paid? Are there any claims outstanding? A lot of these matters are answered.
Yes.
The death figures are 5295. These are paid. Transferred to injury 10,000, permanent disability 3,000, temporary disability 33,000, injury of severity 40,000, minor injuries 521, loss of livestock 233, loss of property 547, PSU 8, total number of cases 5,74,000, compensation paid 154856.
These are the figures given in the review application.
Curative application.
Security. So this is how Malak they paid 1548. Came back to your lordships saying we still have 1,500 lying in the kitty. So pro rata compensation given. Now, what the curative petition tells your lordship is page 150 of volume 1, the lordship sees it side by side. Curative CP1, CP volume 1. The lordship keeps this page open and compares the figures.
What page are you referring to?
150.
150.
And if your lordship looks at D, column D, and compares it to the number of cases column at page 329. F 5295. Permanent disability is actually 4902 as against 10,040. Sorry, permanent disability is 4902 as against 3199. Temporary disability is 35 as against 33. Utmost severity is the same, 42. Minor injuries, 521 to 527. It's not much of an increase. Loss of property, loss of livestock. It's not that what has been paid and what are the actual number of cases in the curative are dramatically different. What then are they claiming? They are saying compare the figures in D to the assumptions of 4th May 89. What we have assumed and what have actually transpired are different. Now, what had they assumed? They had assumed 3,000 deaths. It turned out to be 5,295. They had assumed 30,000 permanent disability. It actually turned out to be 4,900. They had assumed 20,000 disability temporary. It turned out to be 35. Utmost severity was 2,000. It actually turned out to be 42. It's this 50,000 assumed. It became 5,27,000. Loss of property, 50,000 turned out to be 555. Loss of livestock, 50,000 assumed to be 230.
And even from the chart the attorney had given to us, where the figures were given, we had put to him the real issue is of the solace amount paid to the persons with minor injuries.
Not even that, that also has been paid.
No, paid it has, but this is where the figures rose.
The figures rose from what was assumed in 1989.
Yeah.
Now, the question of law, which you have to consider in a curative, is if the Union of India, which was perfectly aware of the uncertainties of the situation, thought that that public interest would benefit by a quietus of signing the settlement at 470 billion in a full and final settlement, can come back and say, if you knew that the permanent disabilities would be 500,000 instead of 50,000, you would never have signed this settlement. And assuming that is so, does that become a ground to set aside a settlement? Point number one. Point number two, can you add top up? Because Union are not saying set aside settlement. They did. At one time they did. Today they are not saying set aside. And this is the fundamental difference between the review and the curative. Let me not put to one side the question about the procedure which your lordships have put, and the attorney has answered. Nothing I can usefully add on whether, without filing a review, a curative can be filed. It is not merely a matter of procedure. There was something more troublesome there. If the union had to file a review, it would have had to elect on whether it wants to continue with the settlement or whether it wants to discontinue the settlement, scrap the settlement, and say, we don't care about the settlement. Start the suit.
Why would in a review they be required to say so?
It's binary. Either you stay with the settlement.
No, that's the same thing today.
No, exactly. So they don't file a review.
Even in a review, they would have said, look, we don't want to disturb the settlement, top it up, as they are saying in the curative.
They didn't.
They did. As a fact, they did.
No, what happened is something very interesting. Because your lordship will know the background. The review petitions. I'm not saying it may be that it's a technicality that the union representing the review petitioners did not itself file a review, but it came and supported a review, etc. So you may say, in that sense, broadly, the Hura test is satisfied. I'm going on that basis. Taking up time on it. But then that creates.
Having heard the attorney for such a long period of time, we are not going to shut him out because the curative has not been
Exactly.
taken. So
I am not wanting to point out something else. Your lordship tells.
Mr. Salve, one more thing, please. This was a settlement in this court. Now review is filed. Review is granted. Now under Order 43, the grant of review is appealable. Specifically as an order of court. Now, if you're going to shut him out on curative aspect, then it will lead to a very.
I'm not saying that. I'm not saying that. That's why I said
that's what
I'm not addressing a lot.
we already indicated. We have flagged that issue, but on that,
No, that's why I
issue,
said I
we
don't
would
even
not
want
like to shut out
I
the.
only said I'm not going there. What I want to show my lord is something.
To that extent, you are right.
What I do want to show my lord is what exactly happened. To inform the court. Please turn to volume 6, additional documents filed by us. This is the review petition prayers.
You mentioned the review petition prayers were to set aside the settlement.
Yes, I want to say.
But that's by the other
The
people.
union said we support the review.
But the union never argued that the settlement be set aside at any stage.
I remember right in the opening, a subject matter dear to my Lord Justice Khanna and my heart came up, tax law. Because one of the first questions which came up was, having appropriately money under a settlement, can you challenge the settlement? Then Attorney General, my guru, Mr. Sorabji said, we have not appropriated the money. We produced a copy of the finance bill. So there was a question of taxability of the interest on the purpose. So a provision was introduced in the finance bill appropriating this money and saying it goes to the exchequer. So there'll be no interest. There'll be no tax on the interest. So we said this constitutes appropriation. This issue was very much at large. And what the union asked for is not set out fortunately for us. As Justice Venkatachala said, because nobody was hurt, we didn't keep it in the traditional confines of a review. Like your lordships have heard this case much beyond the confines of security. The lordships, in fact, said we will hear if the settlement has to be set aside. That is what was being heard. Because at page 1433, just to get the record straight. Lordship read that rather poignant comment by Justice Ranganathan. It's very easy to say, go try the soup for those who have no stake. Those who know the realities of the uncertainty of litigation will never make that prayer. Look at page 1433. Review the orders of settlement. Allow the appeal of the Union of India against the Madhya Pradesh High Court and confirm the order of the District Judge Bhopal. The Lordships have paid on this. Direct the disposal of 350 crores as interim compensation to the victims. So, my lord, this would be on the basis that the judgment goes. So, we are back with the appeal. allow the appeal of the Union of India against Madhya Pradesh because the High Court had gonna scale down the pro tem compensation
Yeah.
from 400 to 250 crores. So allow the appeal of the union, confirm the order, direct 350 crores as interim compensation out of the sum deposited by UCC. Retain the balance of the amount paid by UCC in the court as security to satisfy the final decree in the suit.
What was the total amount paid in court at that time?
Manoj, this was the total amount paid under the settlement, i.e. the 400 odd millions. 470 million.
I believe before the district court it was 270, and the high court it was 140, and when it has come to this court, then it was 470.
Yes. So, but that is how, and that money was paid pursuant to settlement. So the review petitioner
I
said,
was only saying what was the amount which is already in court, either in district or high court.
no,
or-
by the time this was filed,
Yes.
the entire amount under the settlement had been paid.
So that was so you brought in more money under the settlement.
Yes.
So that's what I'm saying. I'm saying originally what was lying in the court was
5 million.
deposited.
I don't think, I mean, subject to
So
correction.
pursuant to the interim direction,
There was a direction to pay.
I'm saying pursuant to the direction of the district court and the high court, was any amount deposited
No,
or not
because that was carried in appeal.
deposited? So it was not deposited.
No.
That's a fact I want.
And the appeal came here.
That's fine.
Post settlement, the entire amount was brought in. And there's a certification, it's all noted.
So it's 5 million paid pursuant to the US Justice Kinnan's order. 5 million. That was the only advance amount paid. Rest was all paid later on.
Very small amount.
That's para 2A.
There's a very interesting thing I discovered in this. Although people retire, even in the US, they have the right to call back judges. Judge Keenan kept hearing the Bhopal case in its repeated avatars. Even post-settlement, Marat 3 trials were held. They used to call him back. I think the last order he passed was at age 90 or something. He heard an action because they used to call him back to hear the Bhopal case.
The lighter side, your suggestion is all reviews here should be dealt with in the same manner.
But we have to seriously consider, even in the English courts, retired judges are so many times called back by the commercial court. Come for a few days, sit, decide individual cases. 1433, Marat.
Yeah.
If your lordship sees the operative prayers. So what they said is of the settlement money which is coming, 350 you distribute, which is as per the interim order. Retain the balance in security to satisfy the final decree. Please mark the words. In the suit against street pending in the district court of Bhopal, and direct the speedy and expeditious disposal of the suit against the UCC by the district court and pass as a consequential orders. The union cannot file a counter affidavit, which is at volume 7, and that makes important read.
In my review underline, like in my volume and yes.
This is volume 7.
What do you want to show us from this
Yes.
volume, Mr. Salve?
Please turn to page 1594. In the middle of the paragraph,
Yes.
the victim groups submitted. The victims group submitted certain material and studies to the government. Thereafter, the government took a fresh look at the matter, with particular reference to the long-term effects and potential hazards of the exposure of MIC and other toxic gas. And it was realized that an important element involved in the determination of liability and the assessment of compensation damages was overlooked, as stated here and after. While directing settlement, the court took into account the number of fatal cases at about 3,000 and the number of cases of grievous and serious personal injuries as verifiable from the records of the hospitals of cases treated at Bhopal was taken to be in the neighborhood of 30,000. Obviously, one of these figures didn't come from Union Carpet, it would only have come from the government. It is submitted for reasons stated that the figures are not accurate and do not furnish a sound basis for assessment of compensation damages to the people who have been exposed to MIC and toxic gases. It is further submitted that medical studies on the effect of MIC and toxic gases formed in the leakage have been conducted under the auspices of the ICMR, and further studies are being conducted, and a whole chart of other studies is made. Your Lordship turns to page 1596. Results already obtained clearly show evidence of psychiatric disorders such as anxiety, neurosis, and depression, pulmonary damage, visual disorders. With regard to pulmonary damage, etc., etc. Then, my lord, page 1597. Some suggestion being made at that time, cancer was not known, this was not known. 1597, fourth line. Besides, there is a likelihood of carcinogenic effects which may be manifested over the years. Research and investigation in this regard are continuing. In addition to the studies of long-range effects are in progress in order to evaluate genetic risk, organic brain damage, damage to the immune system. Follow-up studies are being conducted in children, etc., etc. Page 1598. 8. It is also necessary to point out that while the court proceeded on the basis that the number of dead was 3,000, the total number has gone up to 3677. The figure is based on records showing ex gratia payments to the next of kin. It is therefore submitted there is every possible of the number of dead increasing as the various results of the gas leak manifest themselves over a period of time. The environment damage, etc., is all mentioned, and the operative. Then, of course, they challenged successfully the quashing of the criminal case, and page 1608, para 23. The union says the settlement requires to be reviewed. With this backdrop, I just wanted to read a few paragraphs from the review document. Two or three things, but I just wanted to clarify. Page 39, I'm sorry, page 601, printing, but I'm reading slightly some other one. Paragraph, page 600, 601.
We have
Which
the other-
page 39 of the paper book, security paper book, but my lord may have read it, the attorney read it from some other volume.
So we had.
No, it is
we-
right. 39 is the right.
we
601.
kept the file, that file.
Which is the paragraph number?
Paragraph 5.
United States Court.
Yes. Something with Justice was read from Chief Justice Mishra's judgment. I just wanted to correct-
Para 39.
Yes, page 39, para 5. The United States Court of Appeal for the Second Circuit upheld the first condition in respect. So, in fact, the two conditions was Union Carbide shall consent to submit to the jurisdiction of the court and continue to waive defenses based on statute of limitations, and Union Carbide shall agree to satisfy any judgment rendered by against it in the Indian court, and if appealable, upheld by an appellate court in that country. Whether judgment and affirmance comport with minimum requirements of due process. Now that condition, my lord, was appealed, and that condition was set aside. The U.S. Court of Appeals for the Second Circuit, by its decision of 14th January, upheld the first condition, and for the second one stated, if your lordship sees in the middle, it says of that para passage quoted, under the New York law, which governs actions brought in New York to enforce foreign judgments, foreign country judgment is final, conclusive, and enforceable. Where injured must be recognized and will be enforced as conclusive to the extent it grants or denies recovery of a sum of money, except that it is not deemed to be conclusive if the judgment was rendered under a system which does not provide for impartial tribunal and procedure compatible or procedures compatible with the requirements of due process of law. And added, over the page, any denial by the Indian courts of due process can be raised by UCC as a defense to the plaintiff's later attempt to enforce a resulting judgment against UCC in this country. This is what the court was faced with. The explanation given, page 42, para 10. One or two things, page 604 of the report. One or two things required to be explained. The attorney said he will show your lordship's jurisprudence that a settlement can be increased or enhanced. And he has filed 3 American cases. He didn't read them, so I'm not dealing beyond pointing out. This is brought against companies. So I'll talk about that. They have an interesting procedure in mass tort. This is the procedure under their. What happens is, unlike our systems, where your statement of claim or particulars of claim, or as we call it, claim, must set out your material facts, your basis, your evidence, and your summary of evidence, and your reliefs and your cause of action. In America, you only file a cause of action. So and so has committed fraud, cheating, deceit. I claim so much. That's all that you do. Then the discovery procedure starts. Then you ask for all the documents, and then you go on filing particulars of claim. So the mass tort lawyers, they are one of the bar is divided, the plaintiff's bar and the defendant's bar. So the mass tort lawyers, it's always who comes first and files the first claim. Multiple mass tort claims come to be filed, and of those multiple claims, then it becomes a race as to who gets the lead of the case. Now, in that one, they have a procedure of a global settlement. So if there are 100 suits, you have a global settlement. All the suits of the mass tort get settled. Now, in that global settlement, you have a right to challenge. So different people whose suits are perforce getting settled, they can come and say this settlement is wrong, or these figures are wrong with that figure. That's one of the two, including the one US Supreme Court case, which was cited, where a global settlement was challenged. And what are the principles? Now, we can't import all of that. None of that is relevant for us. in those mass fraud settlements, sometimes you insert what I call reopener clause. That if a set of circumstances come into being, it will be reopened. Today, we're not inviting our lordship to add a reopener clause to our settlement itself and setting aside the settlement. The settlement was challenged in the review on the ground that in mass fraud cases, you must always have a reopener clause. This settlement did not have a reopener clause, therefore it's banned. And that was rejected. It's 43, page 605. Second line. The fact that the Union of India has taken over the right to sue on behalf of all the victims indicates that if there is a shortfall in the fund, perhaps it would be the liability of Union of India to meet the same. Some of the observations of the Vairis bench support this view. This is not the Charalal Chau case. The genuine claimants thus have no legitimate grievance to make as long as the compensation statutorily quantified is available to them, because the source from which the compensation comes into the fund is not of significance, relevance to the claimant. Nothing has been shown to your lordship, Maharaj, in the parliamentary legislation to establish that this is such an egregious error of law that your lordship must revisit this. But Parliament made a law saying Union of India will consolidate and pursue the claims on behalf of all victims. It was for Parliament to say that of the money received, to the extent received will be paid, to the extent not received will be paid. The Union of India will make sure whatever is paid is recovered from Bhopal, etc., from UCCS. But there was nothing. And when the union argued, they said, we are taking full responsibility. Because what Mr. Garg's argument was, you have taken away my right to sue UCC by the Bhopal Act. Nobody else, I can't sue. You've taken away my right to sue UCC. Tomorrow, if I'm not happy with the judgment, what happens? And the answer was, the government of India is accountable to you. That's how the law was upheld. That's what Justice Mishra is referring to. The virus bit, the virus judgment, which upheld the Bhopal Act, was on this basis. If your lordship now might move to the to para 16, consciously, the review bench says we are not saying whether we are not applying the MC Mehta principle.
46.
And they are saying so for a reason. If your lordship sees para 15 and 16, the last three lines of para 15 are very important. In fact, Bhagwati Chief Justice clearly indicates in the judgment that his view is a departure from the law applicable to Western countries. We are not concerned in the present case as to whether the ratio of MC Mehta should be applied to cases of the type referred to in India. We have to remain cognizant of the fact that the Indian assets of UCC through UCI are 100 crores. For any decree in excess of that amount, execution has to be taken in the US. And one has to remember the observation of the Court of Appeals that the defense of due process will be available to be raised. The decree to be obtained in the Bhopal suit would have to be a money decree. It would be subject to the law referred to in the judgment of the US Court of Appeals. If the compensation is determined on basis of strict liability, a foundation different from the accepted basis in the US, the decree would be open to attack and may not be executable. Nothing has been shown to your lordship that this is an egregious error of law or the review bench made some horrible mistake in coming to this conclusion. Today, your lordship is told, please apply MC Mehta. But the review bench heard that argument and said, no, sorry, we are not going to do this because we don't want to put in peril the ultimate recoverability. And my lord, please turn to Justice Venkataraya's judgment. It starts Page 48. Page 48, para 25. It begins here. And the point which the attorney made at page 50, para 30. The last line, in fact, against his point in the curative. The hazards of exposure to this lethal poison are as yet an unknown quanta. The court is perfectly aware that we don't know where this is going to end. It's not that now you realize that you don't know where this is going to end. You knew then that you don't know where this is going to end. Page 51, para 33, last 4 lines. One of the points urged is that the likely long-term effects of the exposure have not been taken into account in approving the settlement, and the only way the victim's interests could have been protected against future aggravation of their gas-related health hazards was by the incorporation of an appropriate reopening clause. So this was argued. I can understand, in my humble submission, I perfectly understand this argument if you are challenging me, saying, look, a settlement without a reopener clause should be set aside. Then, my lord, please turn to page 55. My lord, this should be the last word as far as this is concerned. At paragraph 45, your lord should say, on February 89, this court recorded an overall settlement of the claims in the suit for 470 million. Reading page 55, printed page 617. The first 2 lines of para 45. This one closes the debate. Old Alture principle must apply now. What is said in a judgment is the last one. If your lordship say this is the settlement, this is the settlement. Look at para 46, first 3 lines. On 15th February, the terms of settlement signed by the Attorney General or the Union of India and the Council for UCC was filed and the whole memorandum was set up. Then came the consequential orders. Para 48 at page 619. The first sentence is important. The settlement is the same in this review petition and writ petitions on various. So the settlement was squarely challenged. Page 621, para 54. At the outset, it requires to be noticed that the Union of India, which is the party to the settlement, has not bestirred itself to assail the settlement or any motion of its own. However, the Union of India, while not assailing the factum of the settlement, has sought to support the petitioner's challenge, please mark the word if you don't mind, to the validity of the settlement. The Union squarely challenged the settlement. The Learned Attorney General submitted that the factor of a compromise or settlement recorded is not disputed by the Union of India. So that there is a settlement, Union of India doesn't dispute. The learned Attorney General also made it clear that the Union of India does not dispute the authority of the then Attorney General, an advocate on record for the Union of India, in the case to enter into a settlement. I dare say, I don't think Ms. Subhashini used to work for the central agency, thought her name would be remembered in posterity in this way. She decided to settle. But he submitted that this should not preclude the Union of India from pointing out circumstances which, if accepted, would detract from the legal validity of the settlement. All the contentions are noticed on it. I won't take up your lordship's time reading them. In fact, just to give your lordships the para numbers, in para 64, 65, your lordship said we could, if it was correct, have even quashed the criminal case. We have the power. But on facts, your lordship said we should. So the power of the court is upheld. Number one important factor in the chronology of events as they evolved in those days. The settlement was arrived at when the challenge to the validity of the act was still pending. So the settlement became a point of argument in the act challenge, in the virus case. And one of the points was raised by Mr. Shanti Bhushan, saying Order 23 Rule 3B principle should have been followed before entering into the settlement. Your lordship said that we did not set aside that settlement. And it was in that context now a full discussion is done. Please notice at page 632 printed, page 70, para 77, but that order of 15 February has been read, reread, and beaten to death. Please just see, ma'am. The order of 15 February refers to written memorandum filed by both learned counsel. Then starts the discussion from paragraph 106. One of the arguments was that this amount was composite for civil and criminal, and therefore it was for stifling prosecution, and therefore opposed to public policy. Your lordships reject that. Your lordships allow the union to argue that point at para 108. This point ends starting from para 115 and ending at para 122 at page 650. On a consideration of the matter, We hold that the doctrine of stifling prosecution is not attracted in the present case. About the unfairness hearing. Sure. Yeah, sense of proportion. Now, Malad, two important things, please see. Page 120, page 652, para 127. Your Lordship, a sense of what is the lay of the land at that time. We may at this stage have a brief look at the work of the medical evaluation and categorization of the health status of the affected persons carried out by the Directorate of Claims. It would appear that on 31st October 1990, please mark one 639,793 claims have been filed. So that finally that 500,000 claims came to be accepted. Even in as early as October 90, there were already 600,000 claims. Because they are in curative. If in review this was not considered good enough ground to knock the settlement sideways, this can't be a curative, can't be a second bite of the cherry. It goes on to say, it was stated that a considerably large number of claimants who were asked to appear did not turn up. Medical folders, total number of deaths had written so and so. Medical evaluation has shown so and so. Then a whole figure is given. Para 129 speaks of the latency period of toxic injuries that was in the mind of the court. And what is important? Is the discussion at page 655 from para 130. I don't propose for that. I will finish quickly. I don't propose to read all these paras. There is a full discussion about whether you can have multiple actions sequentially.
Split trials for pontificate.
Split trials. And this whole the whole discussion goes on. And at para 134, this point is put to rest. The petitioner said that in the process of evolving what is fair, reasonable, adequate, some of the elements of essential relevant to fairness and adequacy, such as provision for future medical surveillance and the likely future but unforeseen manifestation of toxic injury, having regard to the nature of the hazard, have not been kept in mind, and therefore please mark these words. The approval accorded to the settlement is on an incomplete criteria. But the UCC would say that the Union of India was aware of the possibility of such future manifestations of the effect and must be deemed to have kept those in mind at the time of settlement. But the point to emphasize is those who are not parties to the process of settlement are assailing the settlement on these grounds. In personal injury actions, the possibility of further aggravation of the condition and consequent aggravation are taken into account in the assessment of damages. The estimate of damages is a very delicate exercise requiring evaluation of many criteria, some of which may border on imponderable. And then the whole discussion goes on this. And it ends by saying, even if the award is a once for all determination, these aspects will be taken into account. And then, after discussing the fairness hearing principle, page 97. In our opinion, I'm showing this because American jurisprudence have been.
What is the paragraph number?
I'm so sorry, para 140. The American principles, your lordships have said, will not apply. Para 140. In our opinion, the right of victims read into Section 4 of the Act to express their views on proposed settlement does not contribute to a position analogous to that in the United States, in which fairness hearings are imperative, either on their global settlement. Section 4 of the Act, to which right is traceable, merely enjoins the Government of India to have due regard to the views expressed. The power of union under the Act to enter into a compromise is not necessarily confined to a situation where the suit came to be instituted on behalf of the victims. Statute enables Union of India to enter into a compromise even without a suit. The right of being heard and read into form and subject to its constitutionality has been upheld in Sahu, subjects the Union to a corresponding obligation. But the obligation doesn't envisage a procedure like the fairness hearing as in the condition precedent to a compromise that the Union of India may reach in a situation in which it may do not necessarily to a suit. Accordingly, contention G is answered. We hold settlement is not vitiated for the reason alone for want of a fairness hearing. Likewise, the settlement is not vitiated by reason of the absence of a reopener clause built into it. Now, my lord, your lordships have not been shown any statute which was overlooked by coming to this conclusion, or some binding judgment of this court to the contrary, which was missed. In saying in a curative, this is a big egregious error. Please correct.
So, whether contention of the Union of India that award this consent order should be set aside, settlement should be set aside. Is it recorded anywhere at the time of hearing in this judgment?
Yes, my lord, Union of India challenged this.
No, whether Union of India argued before the review court that the settlement should be set aside.
Yes, they did. In fact, they went to the extent of saying this is for stifling prosecution opposed to public policy. Set aside the whole settlement. In fact, para 142, it immediately answers what Madam Justice Oka is putting today. Para 143, please see.
12 also.
Yes.
The stand of the Union of India and other petitioners is that even upon setting aside of the settlement, funds should not be allowed to be repaid.
Right.
So they clearly challenge. Now the question was, what happens to the money? Your lordships in 142.
Well,
05, you read out.
Para 12.
Yes.
In here, Chief Justice Mishra's
Yes.
judgment.
Union of India, paragraph 9, sorry. Paragraph
9.
Nine.
Correct. Supported the stand.
Correct? Who have asked for a review. And in fact, one of the subject there to Mr. Vikraj, he wanted me to read a paragraph. There, the union was criticized. The union was criticized for running the stifling of prosecution point. Where your lordship said, we hold that the doctrine of stifling prosecution is not attracted in reaching the conclusion. You don't put out a consideration that Union of India would, under threat of prosecution, coerce UCC to pay 470 and apart. In the context of the Union of India, the plea lacks as much reality as any sense of proportion. In fact, the argument was interesting. It is bad because under threat of prosecution, UCC agreed to pay. Lordship said this argument is not only bad, it lacks sense of proportion because. Please see page 98, para H.
Para H.
Yes. This also, my lord, answers your lordship's point.
Right.
If your lordship sees para 3,
Right.
Keep the money back till such time when the decree is passed in the suit. What they were saying is restitution, yes, we will keep it in trust to appropriate against any decree which may be made.
Suit should go back then.
Suit had to be tried. page 661, para 146.
146.
Then one of the arguments was, may I read from 145? The learned Attorney General also sought to point out that UCC had subsequent to the settlement effected certain corporate and administrative changes. And without a full disclosure by the UCC of these changes and their effect on the interests of the claimants, the fund should not be permitted to be taken out of the court jurisdiction. However, Government of India also should not be free to appropriate or use the funds. We are not impressed by any of these contentions. It is not shown that the UCC brought in monies with any undue haste with a view to confronting Union of India with the fait accompli. The records indicate a different complexion of the matter. The payment appears to have been expedited at the instance of the Union of India itself. Strictly speaking, no restitution in the sense of any funds obtained and appropriated by the Union required to be paid by the PAC arises. The funds brought in by UCC are deposited in the RBI.
Ultimately, court says that restitution will follow, but that safeguard should be maintained.
Correct. Well, that will be, but they said in any case,
Right.
it will be done.
Court says.
Because Manoj, one very important thing your lordship say in 148, and this is the strength of our system. However serious the incident may have been, the rule of law, Manoj, has to stand.
Yeah.
And in the middle of para 148, your lordship says it is the duty of the court to ensure no litigant goes back with the feeling that he was prejudiced by an act which he did on the faith of the court. That's a very important consideration. Then para 153, your lordship says, we are satisfied.
Just one minute, just one second.
Now it's more. And what has become more is 50,000 has become 500,000. or minor injury. That's the long and short of the curate.
Yeah.
Manan, I submit that fact, there is no top-up issue. That's, I don't think I can assist your lordship anymore on this. There are a series of, I'm only staying it in 2 minutes. Series of affidavits filed. Series of affidavits starting with 1994, 1995, and ending as late as 2011, where the Union of India has opposed every single attempt to suggest that the settlement is inane. Affidavit upon affidavit upon affidavit. Argument before your lordship says the settlement has become adequate because the rupee depreciated. Go back to 89 and compare. But that can't be a ground for top-up. In the long and short of my submission.
So Salve, which are the pages of the affidavits where prior to curative?
Yes.
They keep saying that.
That's very important. May I very quickly show 4 or 5 pages and then I'm done.
Just give me the page numbers. That's all.
First is volume 9, 12 December 95.
That is your volume 9.
Yes, ma'am.
December
95. There's a,
What page is this?
yes, it starts from at page 2149.
Okay.
Please just,
That's fine. Next.
yes, please just mark para 5 and 6.
Yeah.
Then, my lord, 2003, there is a 32 petition file in which your lordship direct disbursal, where this 1300 crore figure came in, the 1500 figure came in. That's only one out for the record. Your lordship's order is at page 2067 of volume 8.
Mr. Salve,
Yes.
can you do me this favor on a ask the instructing council on
a piece of paper.
Just give the.
There is a written submission which I am filing and which I am inviting your lordship not to waste your time reading, except maybe
Does it
to
have
assist you on these
No, no.
pages.
Does it have the paragraph number?
Yeah, it
That's all.
does. Beyond that, my lord, please don't waste your time reading it. I mean, it says nothing more. It says in 20 pages what I've said. 10 minutes to your lordship. And I don't think the matter requires.
I just need those instead of noting down, so there is no easier to locate those. That's all.
Are you doing it? TDCC, we don't know. Copies, please hand over. Your lordship had asked us to file written notes. So this is that written note. What your lordship is looking for. Yes, it's in Roman 5, page 7 onwards. Extracts are given in page number.
Thank you.
But unless there's anything else I can assist.
Thank you.
And since your lordships have not discharged the alternative board, I take leave.
Thank you.
And we asked to go through court once.
Anything you want to say, Penny?
Not just to. Sorry.
Yes, anything else, Attorney? I think both of you already debated it. What can be an agenda in this?
I think we will even do it even earlier if possible.
No, you want to say something? I thought there's nothing to say one way or the other. We have understood the point. The point is in a limited compass. Yes.
It won't be any manner of repetition.
Okay.
To tie up certain threads.
May I be excused?
Either threads are open or closed. If they are still open, how will you tie them?
No. We have traveled quite a distance in understanding a lot of things had to be unraveled to comprehend. There are so many things that have happened over a period of time. And I looked at, again, there are three claims in the curative petition. One on the compensation amount to be upgraded. The other in relation to the environment mitigation, and the third in relation to the expenditures and rehabilitation and all that. So when the curative petition was filed, the Madhya Pradesh High Court was still in season of a writ petition filed challenging the issue of environmental mitigation. And the respondent then entered appearance, some objections were taken, and I'm told they had placed before the High Court certain documents in confidence, which I had no idea at all. And after the review, the curative petition was filed, the Union of India had filed a transfer petition, which is also tagged along with the curative petition and is heard along with that. But since the High Court is in season of the matter, the question whether they would be subject to a liability on that question or not is still a matter at large. And I don't think in these proceedings I could probably ask your lordships to go into that question because a number of other issues that arise, I don't think
that may not be appropriate.
Fairly stated and on a high level of integrity of the procedure. We are confined to the question of the liabilities as far as the quantum of compensation for the victims are concerned.
This transfer
So muddle up.
The TP is also listed before us.
Yes.
TP is listed. There's a transfer petition which is
501.1.
That is filed by you.
Union of India had filed a transfer petition, and the transfer even was not even ordered. Unfortunately, it was lying pending with the court.
So simplest thing is to pass it.
So what it says in the High Court is in season of the matter, and the High Court will continue to hear the proceedings.
Dismiss the transfer petition. That's all. Don't say anything more.
And say the High Court will give the petition number.
No, once we dismiss the transfer petition, that means we are not transferring it before us. That's all.
And I know, but anything Lord's mistake regards the continued liability to the UCC, and this may or may not come in the way the High Court will.
You've not.
On the question of any liability on any other account, because I know there are some passages in the judgment which
we are not touching
obliquely looks at it, but I don't think directly has a bearing on it. And the other issue also I think should be connected with. I don't think I can also go in the question of the rehabilitation exercise compensation paid on that. Because that's a matter on there could be more than one point of view, some factual, today we not even spend that money. How much more we'll spend all that? I don't think. So though they are part of the claims for some very policy reasons, they've been brought as part of the curative petition, but maybe for good reasons, I would confine myself a little bit. Now I look at the turn of events over a period of
claim
time.
3 you are not pressing.
Yeah, they can be pursued in accordance with law in appropriate procedure.
Yes. Claim 3 goes there.
That's right. Review judgment broadly looked at 2 or 3 troubling issues. While it is true that Union of India did not itself file a review petition, but supported the review proceedings, and in the penultimate paragraph of the affidavit, it says that the settlement may be deserved to be reopened. So the extent of reopening, the nature of the degree of opening, whether it is to completely undo the settlement or to have a review limited to the extent of looking at the quantum of compensation, were probably that was the main focus, it seems to be, as I read the affidavit in total.
See, in the
Not that-
background,
that
in the background of the order in the review petition, you are wiser in the curative petition to the extent you would like to claim.
Maybe
All
wiser,
I'm
little
saying.
more wiser.
So
No, I look at the, I
were-
look at,
Therefore, you were fair to say that, look, in view of the proceedings gone by, it's not even advisable to pray for reopening the settlement. What you are, therefore, any time I said you want the settlement to be topped up.
exactly.
Yes, it has happened. There are certain other
Exactly,
facts,
exactly.
supervening circumstances
Exactly.
and facts which would require the court, according to you, to exercise whatever inherent power, whatever power you feel, look at a larger conspectus of the situation.
Great.
And in that process, you feel something more should be added to
That's-
it, given the figures and facts and figures which you
That's. Well, I look at the affidavit only from that perspective, and I think that must have been the whole idea behind it. I don't think Union of India, having gone into the settlement and supported it, said right for the immediacy and all that, but I said undo the settlement fundamentally. I don't think that was probably the intention. So the review judgment had looked at some of the basic concerns urged on behalf of the claimants and the writ petitioners. One is that having been kept away in the entire process of adjudication and Government of India had taken over the right to represent us. So there are several casualties, the fairness hearing and the participation in the settlement procedure and so on and so forth. And the quantum of settlement, the figures, how do you arrive at these figures? There could be no finality at this point of time. All those very important concerns were raised before the court. And they're all summed up in paragraph 55 in several contentions, paragraph 55 of the review judgment. And there is observations made in the context of one, probably has been read in the context of some other contention. Therefore, I thought important for a purpose that the contentions raised in respect of each one of those must be kept within the scope of those contentions. And sometimes you read one in the context of one. That could
Those
be
are
a small.
points A to H. A to H.
That's right. Now, therefore, the paragraph 55, contention F is about. This is paragraph 55 of the review judgment. So I read from volume 1 of the respondents' compilation. The other contention relating to criminal prosecution, court settlement. I'm not looking at all of them. Contention F is the memorandum of settlement. The orders of the court thereon properly construed make inference inescapable to the part of the consideration whether stifling of the criminal prosecution is opposed to public policy. This vitiates the agreement on the settlement is based on unlawfulness. That one contention relating to criminal prosecution. Then turn over to contention H.
That is regarding restitution.
Contention H, yes, restitution. Even if the settlement is reviewed and set aside, there is no compulsion or obligation to refund and restore to the UCC the funds brought by it as such restitution is discretionary. Excise and discretion, the interest of the victims is kept in mind and restitution denied. But all even if restitution is to be allowed, the UCC would not be required to act upon and effectuate its undertaking dated so and so on the basis of it order dated so and so, vacating the injunction against us made. Then contention J. That the settlement required to be set aside in the original suit directed to be proceeded with on the merits. If so, and what other reliefs required to be granted, what are the directions required to be issued. So when you read contention J, let me read the first with contention H at page paragraph 142. 188. Same time, it's necessary to remind ourselves that in bestowing a second thought whether a settlement is just and adequate, we should not proceed on the premise so has been finally established. Yet to be decided in the matter goes to trial. Because all those things went into the decision-making process of the court, looking at whether I should undo the settlement at all. So when the court has ultimately thought we're not going to undo the settlement, but will still, that's why when it gave a final thought on the question in paragraph 205 about what happened to the future symptomatic now, asymptomatic now, symptomatic later. So that's where those people may come for a claim later, we should take care of them. It ends at that. It ends at that. I would probably look at us, the Lordships, to read this review judgment and the first order of May 4, 1989 together. Please read them together. Even if there was no reopener clause in the settlement, but the court in the 4th May 1989 order, the final paragraph, for all practical purposes, is the reopener clause. It is a reopener clause which the court has introduced into the settlement because the wide range of complexities which a matter of this nature was brought to the fore of the court. If I am not too off the mark in requesting the court to read it as the reopener clause, kindly come back to that. It's been read again and again, but so paragraph 38 of the settlement justification. So having said this, I thought, the way one can read it fairly, the review judgment thought there is already a certain guarantee and that can probably take care of. That's why although the arguments about settlement did not have all these concerns, those fairness opportunities are not there. So that, I think, in all fairness, to whatever extent justice may be done, paragraph 38 may be read as the reopener clause, and we read these judgments, we read as one continuum of a judicial process. They may have happened at different points of time, but one.
No, but in fact, settlement was specifically challenged on the ground that there was no reopener clause, and that
in the settlement.
Correct. And that contention has been specifically
That's
rejected.
right. That's right. In the settlement, there was no reopener. But while the court endorsing the settlement had this in mind. So what was lost in the settlement was compensated and adequately taken care of with this paragraph. In all humility, and I don't think I'm doing injustice to reading judgments this way. If the judgment meant something, that's why I said this probably would not go in vain. So if that would not be too wrong to read it as part of to judgment to be read as a continuum, and this as a reopener clause, to whatever extent Union of India got to your Lordship's notice, the unfolding events over a period of time, and I also read out that the ex gratia payment will be excluded under the scheme of the Act and all that. That's why I thought it is in a matter like this, while the undoing of a settlement has been put to rest by a curative petition and having regard to the intent of the Union of India in the affidavit filed in the review proceeding, the curative petition must be taken to a certain level where if the ends of justice of those waiting for justice for long can somehow be secured. And that's where probably the curative petition will be looked at. I've seen all those proceedings in US. I placed on record about the complete lot of settlements. And those, I just give an index of those documents, where the US procedures on fairness hearings, and there are doubts raised whether for future claims, how do you look at them? So a bankruptcy process is also sought to be introduced in all those settlement issues. So it has flown in different directions. But ultimately, it's kept open. All these long proceedings in US, as business particularly, it kept open the possibility for people to secure probably the ends of justice at some point of time. So you put it at a higher level of principles of natural justice. And like all that you say is, I'm sure I must have had my day in the court Your Lordships, that's how it's put. So ultimate questions come to the mind of a claimant is, did I have my day in the court at all? I have so many years of waiting. So yesterday I did not point to Your Lordships about those fraud and mistake. Just a couple of paragraphs of
Paragraphs of what it's in?
I'm not looking at those documents about suppression of facts as a fraud from the point of view.
What are you proposing to read?
Your Lordship, please.
What are you proposing to read? I want.
No, I'm just giving. We have placed on compilation of articles and extracts from books.
Yes.
It is a yesterday, while Your Lordship rising, the concept of a fraud mistake is so wide. It's so wide. That's all I wanted to point out. If it is so wide,
Not the spirit, then say arguments concluded or the result.
Point, my lord, I wanted to-
No second, third, fourth.
It's only, what I'm trying to say is only, my lord, it's a very.
Please understand, some discipline of the court
I
proceedings
know,
must
my
be
lord,
maintained.
I'm
We have heard both of you
No, I'm
against
not-
reasonable time. Now in a rejoinder, we will not.
Not rejoinder, but I'm just trying to inform them. No, not rejoinder. What I'm trying to say is, Lord, there is a figure which has been given. Now, in addition to that, once the medical, documents are made available, it will increase, plus not the future. So therefore, that will be an already of the problem. That's all I wanted.
Thank you.
I'm grateful to that.
Keep your black.
Thank you.
Thank you.